Thank you, everyone. Good morning. So welcome to day 13 of the Inquiry and Advisory Committee hearing for Kentbruck Green Power Hub Project Environment Effects Statement. This hearing is being audio recorded and the recordings will be available on the Engage Victoria website. My name is Lisa Kendall and I'm the Chair of the Inquiry and Advisory Committee considering the matter. I'm joined by Deputy Chair Member Michael Kirsch on my right and members Lachlan Wilkinson and Ken Joyner. So yesterday was officially day 12. That was a reserve day that we didn't need. So I'm just noting that for the record. This is our last sitting day this week and it is anticipated that it'll be our final day of hearing submissions from the proponent, but I note that we do have a reserve day scheduled for Monday and that the need for that will be assessed towards the end of the day. Next week we're sitting Tuesday, Wednesday and Thursday, and I note that Tuesday we're commencing at 9 a.m, so just advance warning for parties and everybody to be here early on that day, and we'll be hearing submissions on the day from DECA and Parks Victoria. Next Wednesday, we'll be sitting for the morning and hearing submissions from organisations and submitters, including Glenelg Shire Council and the Country Fire Authority. I'll just note for Thursday next week, we're hearing submissions from Save Our Surroundings Riverina, who are calling 3 experts. And I just ask parties to please advise the Planning Panel's Victoria office by lunchtime on Wednesday if you intend to ask questions of those experts. The following week, the IAC will be sitting in Portland from Monday to Thursday. So we have received a number of documents over the last day or so. These have been added to the Engage Victoria website and the document list has been updated, and I'll ask the proponent to take us through its documents shortly. Before I ask Mr. Chessel to do that, I just note for parties that some of the documents provide responses to questions asked of experts or issues raised earlier in the hearing. And I just note it's not an invitation for parties to provide further written submission at this stage, and that parties, if wishing to comment on the documents circulated, can do so when they provide further written submissions the day before you're scheduled to present to us. And of course, you can address them in your verbal submissions to us in your allocated time slot. One document I wanted to note was from DECA, so document 377. It's correspondence advising that DECA intends to circulate a revised marked up version of the Environment Mitigation Management Framework and the Planning Scheme Amendment documentation, but approximately 2 weeks' time, no later than Wednesday the 9th of August, a week's time, a week before the proponent's closing submissions. I might have the timing. I'm losing track of time, end of week 4. So DECA, I just wanted to ask Mr. Tobin, I can see that you're with us. Is there anything that you need to add to that written request before I ask the proponent if they have any comments on it?
Good morning, Member Kendall. Good morning, members of the IAC. The request is made really on this basis. We felt that it was not appropriate to respond to a day 1 version in the knowledge that yesterday we knew we were going to get a day 2 version, and that the most useful course would be to respond to the proponent's substantive submission and day 2 version. There is a series of checks and balances that need to be gone through in presenting material on behalf of my clients, and in respect of DECA, we just need a few more days to prepare matters and then have them signed off within DECA. We're optimistic it'll be before the 9th. We think it's a fair thing simply because it's a week before the proponent has to close, and that seems to us in the circumstances to be not an unreasonable request.
Thank you, Mr. Tobin. Mr. Chessel, do you have any comments?
No, we welcome the opportunity to have feedback on that.
Thank you. Well, that arrangement is acceptable to the IAC, so we'll proceed on that basis. Thank you, Mr. Tobin. And yes, noting that before the 9th is an acceptable time frame. So as soon as that can be delivered, that would be great. The IAC doesn't have any further preliminary matters to cover this morning, so I'll hand to. Oh, apologies. I'll just hand to Member Kirsch, who does have one matter to raise.
Thanks. Mr. Chessel, don't be nervous. This is relatively straightforward. Appendix N of the EES, which is the Air Quality Impact Assessment, refers to a UK Institute of Air Quality Management guidance document, and that's guidance on the assessment of dust from demolition and construction, and that's dated 2014. And the EES adopts a methodology drawn from that document. We've just noticed that since the EES was released and around the time of the assessment being done, there's a new guidance document. It's a 2024 version. So our question is simply, can you provide advice about whether there are any material changes to the assessment or to the mitigation measures arising from that more recent document?
Thank you. We'll take that on notice and we'll respond as soon as we're able.
Thank you. So I'll hand to you, Mr. Chessel, just to run through any preliminary matters at this stage, and I'll ask other parties, of course, before we move into your submissions today.
Okay, thank you. The only preliminary matter that I wanted to address is to introduce the various documents that were filed yesterday, and they generally fall into three categories. The first category of documents are what I'll describe as the Day 2 documents. That is the updated EMF, document 378, the updated incorporated document, document 379, and a table that we've prepared describing updates to the BAMP, and that's document 380. Those are documents that have been updated in light of the evidence that has been given through the first part of the hearing, and we'll come to address you on those changes in due course. The second category of documents are documents that were filed in response to the outstanding requests for information that have been made throughout the running of the case. And if it's convenient to the committee, we thought that we'd prepare a table that summarises how it is that we've responded to the various queries. That table, I'm not sure it has a document number yet, but I'll share my screen and hopefully you have access to that document. I believe it was filed this morning. And this is really a ready reckoner to help you navigate through the relevant materials. The first item on this table is the response prepared in respect of the query raised by Member Kirsch in respect of the reconciliation of Ms Dunstan's position relative to the DTP submission. And what we've done is prepare a technical note, document 387, that addresses that particular question. And Member Kirsch, we can take you to that if you need, but it's a relatively complicated exercise. But when one steps through the relevant matters as identified by DTP in our submission, what one sees is that they've been properly addressed in the mitigation measures.
I have looked at the technical note, and that is consistent with what we asked for and suits our purposes, so thank you.
Okay, thank you. The next item then relates to the clarification or reconciliation in respect of the different accounting for native vegetation removal, in particular tree numbers. You recall that was an issue that was addressed in the evidence. Technical note 38, document 388, contains our response to that particular query. And again, unless there are any questions that the committee has in respect of that exercise, we were simply proposing to table that document as being responsive to that request. The next one then, you'll see that a number of the matters have been responded to in the closing submission, and so we'll come to those matters later today. Relevant items that we address in closing are the clarification about the maximum height of trees, the intended operation of the $50,000 Southern Bent Wing Bat offset fund triggered in certain circumstances under the BAMP. The operation of the Heritage River Act is also addressed in the submissions, as is our position in respect of the necessary revisions to Appendix Z, the draft application or draft consent sought under Section 27 of the National Parks Act. What that leaves then are two additional documents. The first being a document that responds to the material filed by Submitter 82, Mr. Cumming, in respect of pre and post construction monitoring of Brolga around Victorian wind farms. And the documents that respond to that are firstly a report prepared by Mr. Organ, that's document 383, and that's a document that records the matters addressed by Mr. Organ orally in giving evidence before the committee. And as we indicated, we've also had Mr. Gibson and Mr. Van Noster review that document and provide their views in respect of it, and both endorse its contents. The relevant documents are 384 and 385. Then the only other document that's been filed in response to a request for further information or clarification is the document 381, Technical Note 36, which was a document prepared in response to the committee's query regarding visual impact on Lake Monbiong. We'll come and address that further in submission, but you'll see that attached to that technical note is a short memorandum prepared by Mr. Hark that describes certain measures that might be introduced in and around the campsite to ameliorate visual impact. So that's the second category of documents that we filed, that is those that are responsive to those outstanding requests. The third category really comprises the closing submission that we'll address today, and that's document 386.
Thank you. Are there any other further preliminary matters? That's it. Not expecting that there are, but just double checking.
For our part, that's it. Thank you.
Thank you. Lovely. So, Mr. Tobin, is there anything at your end?
Thank you, Member Kendall. I do have one matter which I had to come back to you, or I'd indicated I would come back to you earlier in the week, and it concerned the work done by the Glenelg Hopkins Catchment Management Authority on the Discovery Bay Ramsar wetland work. And you asked me a question which I understood to be whether or not we considered it relevant to the committee's considerations. I'm instructed that DECA was a steering committee member only in respect of that. It is a Glenelg Hopkins document. Glenelg Hopkins, of course, have elected not to be a party to this matter. And it's a document that they would use that they may elect to use while it's on consultation, or they may not, in the discharge of their duties. So it's not something that I can advance to you as being a matter that's material or otherwise to present day decision making.
Thank you, Mr. Tobin. And Mr. Chessel, I will just ask if you do have any comment on that and the document as well.
Yes, we've addressed that in submission.
Yes.
It's obviously a draft document, and so doesn't seem to have or should not have a great deal of weight, but the substance of the document is not inconsistent with the substance of the previous, that is, current plan. And in our view, it's not a matter that bears materially on the assessment that you need to undertake.
Thank you. Thank you. Thank you, Mr. Tobin. And I'll just take a moment to see if there are any other queries before we start. Looks like we're good to go. So, Mr. Chessel, I'll hand to you. Thank you.
Thank you. We're proposing to do two things today. The first thing we're proposing to do is walk you through the Day 2 documentation. And the reason we want to start there is because, of course, it is that documentation that would ultimately form the framework and basis of any approval were it to be granted in respect of the proposal. And what we've sought to do in preparing the Day 2 documentation is respond faithfully to the evidence that you've heard through the first part of this hearing, and identify relevantly for each change the genesis, if you like, of the recommendation and how it's been implemented. I'm going to invite Ms Guild and Mr Wright to address you in respect of these matters. We'll start with the EMF. We'll then turn to the incorporated document, and we'll conclude by walking you through the tabular record of changes that should be made to the BAMP.
Thank you.
So I think the best thing to do would be for the committee to have those documents to hand. They're documents 378, 379 and 380. And we'll no doubt share our screen, which we are doing now, and walk you through those changes.
Thank you. In relation to the changes to the EMF, there were quite a number of matters that were discussed during questioning, and there are of the changes that were endorsed by the experts, there are really very few that haven't been incorporated into the day 2 version, and where that has happened, we've provided an explanation of why the change hasn't been made, which is generally because it's actually already there, or it's a complexity of change that we don't think is justified. So we've set all of that out in the document. There's changes throughout the document in the column phase, which those changes have been made in response to Member Kirsch's query on the first or second day of the hearing, in just reviewing to make sure that those were correctly specified, the timeframe for preparation and implementation of plans. I won't go through each of those. We have also included in a lot of the mitigation measures the word prior to the commencement of construction or similar words, just to make it very clear the timeframe for the preparation of the key plans. That those words were in there for some mitigation measures, but not others. So the first change is in relation to native vegetation and the native vegetation plan. And we've included a clarification there that losses that get adjusted through the Boiler Swamp Road process have to be factored into that plan in accordance with the evidence of Mr Organ. If we then continue, and just to be clear, the format that's taken here is that the yellow so the blue underlined text is something means it's been included since the exhibited version. Red crossed out means that it's been removed since the exhibited version, and the yellow highlighting separates between the day 1 and the day 2 version. In relation to BD02, which deals with offsets, we've got a clarification that the offsets have to be secured prior to commencement of construction. Mr Organ's evidence was, well, that's what the guidelines say anyway, but we thought that it was worth putting it beyond doubt that that's the time frame. BD03 deals with the assessment of tree health along Boiler Swamp Road, and this is the process for reconciling the predicted losses and actual losses, and there are 2 changes there. The first one is to include reference to the current version of the Assessor's Handbook, which was updated just in the last week in response to the changes to the Australian standard in relation to protection of tree health on development sites. So we've addressed the implications of that in the written submissions, but we've included the correct document there. And the second change is deleting some text that Mr Organ had identified as being unnecessary and better left out, because the effect of the text was just to say you have to comply with the requirements and that are specified elsewhere. So he's preferred that to come out. Tree protection zones, the change there is simply to update to the 2025 standard for protection of trees, updating from the 2009 version. The title for BD07, which deals with the assessment of losses on Boiler Swamp Road, has been updated. There was general agreement that a more descriptive title would be useful for that measure. And then there are quite a few changes here arising out of cross-examination, just to make it very clear what this report has to do. The witnesses came back several times to the fact that, well, it has to be to the satisfaction of DECA, And so that provides an assurance that this report will have to cover the relevant matters. But there was also no objection from either the experts or NEOAN in terms of including further detail. The first change you can see there is a reference to DECA regions. You'll see that throughout. DECA has advised in response to the queries about how we should specify which part of this very large department we need to deal with, that DECA regions is the appropriate entity or sub-entity. We've included in there a requirement for the report that that deals with the construction along Boiler Swamp Road to deal with the location of joint boxes and associated infrastructure. Just to make it very clear that that is something that has to be addressed specifically, and the committee will recall from Mr. Wright's submissions that the joint boxes can be located in. There's a lot of flexibility about their location, but obviously they do need to be specified. And then there's been inclusion of a requirement for confirmation that no Applejack are expected to be impacted. And that's a response to some questions from Member Kendall in relation to a requirement to that effect having been deleted from another mitigation measure, and whether that there was sort of something meant by that deletion. And the response was no, there was nothing intended by removing it. We just didn't think that DECA would approve it unless we said no impacts on Applejacks. But it's another matter where there's no issue with specifying that outcome has to be achieved. And then the final point that's been added there is something that was very important and was implicit in the previous measure but not explicit, which is that the report has to actually state what the native vegetation losses associated with that alignment and methodology for construction, what those losses will be once those root investigations have been completed. The next paragraph, there's been a change from deleting the word sampling and inserting the word testing. That's something that's addressed in the written submissions. There were some questions along the lines of, well, is this a proper sampling methodology? And what's proposed isn't, in fact, a sampling methodology. It's quite a targeted investigation, and so that's set out in the written submissions. But we've removed the word sampling because it's somewhat misleading with the idea of a scientific sample. That's not the proposal. And then included text specifying that the root investigation program must take into account the size and species of the trees investigated and stratification along the road, and it must be informed by an arborist. And that's picking up a sort of a package of recommendations from both Mr. Gibson and Mr. Organ in evidence that these sorts of matters should be considered. And the report, being informed by an arborist, is picking up some discussion about something that a potential change to BD01, which is the native vegetation plan, and whether or not that should actually have an arborist report. And we thought that the appropriate time to include the arborist's input was actually in preparing this report, so that you then get an accurate estimation of losses, and then that feeds into BD01. So we've put that in there rather than BD01. And then just got little updates there. Going on to BD08, which is the pre-clearance surveys, we included specific reference to leafy greenhood in accordance with Mr. Organ's evidence, and also made it sort of put it beyond doubt that the surveys for both flora and fauna, threatened flora and fauna, that the species that are listed, it's just an inclusive list, and if other species have to be considered if necessary. BD10, we've included a specific requirement to survey for hollows. That was the subject of some discussion during evidence. And also putting in requirements for salvage and relocation if required. They're changes that are put putting things beyond doubt, belts and braces, rather than things that would have been overlooked if not for the changes. But there's no issue with including those changes and adopting Mr. Organ's evidence that he'd rather see these things specified in more detail rather than less. In relation to the Australasian bittern, there's just been a clarification that the access to the site only needs to be limited during the breeding season. In access to the substation site, that's a site that has more convenient access if it can be used, and so there's no need to limit the access outside the breeding season. Coming down to the bird and bat adaptive management plan, most of the changes are in the plan rather than the mitigation measure. But one of the things that we have done is require the BAMP to outline how proportionality should be considered in assessing potential mitigation measures, including technology. And that's a response to some discussion in the evidence about what the requirement for proportionality added to the mitigation measures and what did it really mean in practice. And Mr. Organ's sort of response was, well, you wouldn't just be going out and doing it no matter what. And it's like, well, we want to make sure that it isn't something that you just have to go out and do no matter what, that there's a process of considering what value is obtained for particular mitigation measures that might be proposed and the use of technology. And that's something that's addressed further in the submissions, the things that need to be weighed up in deciding whether a measure is proportionate. We have included at the end of the mitigation measure just a clarification that the BAMP may be updated from time to time in consultation with DECA to the satisfaction of the RA, just to put that beyond doubt, given it is a very important plan and is intended to be dynamic. And there's a highlighted point there, just the second last paragraph, where there was some discussion during evidence about whether 5 years was long enough and whether it should be a longer period. And the experts said that they were comfortable with 5 years because of this paragraph, which allows DECA to direct a further period of monitoring or other measures if that's what it considered appropriate. So that's just confirming that that change has not been made. Looking at this, I've realised that the sentence that BAMP, at Framework BAMP has been provided should actually be in yellow, because that's a day 2 change. But we just deleted the reference to the Framework BAMP because it was that document's well and truly superseded. So in relation to the BD15, that's been renamed to an ecology fund, just to capture really the way we've been talking about it, which is that although the expectation is that the southern bent wingbat will be a focus of that fund, that it may well be spent on other species and may be more effectively spent on other species. In response to some questions from DECA, we've included a requirement for the fund to be managed by an appropriate independent body and to be overseen by an advisory committee with an independent chair. And the written submissions deal in some further detail about what that body might look like and what who the members of that advisory committee might be. We don't think it's appropriate to include more detail in a mitigation measure at this point in time, but the submissions do take that quite a bit further. In relation to the BD16 and power line visibility, we've included the requirement to have some consideration of visual impacts in accordance with Mr. Hark's evidence, and we've intended to draft those words to say you consider it, but the birds come first, which seems to be the appropriate way to proceed. Turning to the Brolga measures, we just have the same change that was made in relation to the Australasian bittern of ensuring that access to the substation is only limited during the breeding season. And then we move on to surface water. And there were these changes need to be read as a package because a lot of them link together, but there was discussion in particular around upfront modelling and upfront monitoring of groundwater levels. And so they've been integrated into, there's a specific requirement for those to occur upfront, and then there's better cross-referencing to that work that's been done through the other mitigation measures. And so, for example, dewatering now says any discharge must meet the background water quality determined in accordance with the Sediment Erosion and Water Quality Management Plan. And then when we go to the Sediment Erosion and Water Quality Management Plan, it has the clearer requirement for that background water quality monitoring. We've got a few here where we've included timeframes for when things have to be done. There's a deletion in here taking out consultation with EPA Victoria in accordance with EPA's correspondence to the committee requesting that it not be nominated as a consultation authority. There's also the same changes being made in relation to one of the noise mitigation measures. In relation to SW04, we've included the specifics of the watercourse crossings that are to be HDD in accordance with the discussion between Member Joyner and Mr Hughes. And that's just picked up what's specified in the relevant technical report. And then at SW06, we've again got the requirement for the CEMP and the Sediment Erosion and Water Quality Management Plan, which I think should be renamed, to be informed by the flood and hydraulic surface water modelling undertaken in accordance with the later mitigation measure. So this is one of these cross-referencing improvements to get a consistent set of data prepared and then keep going back to it. And then SW07, what was in there has been taken out because it's been moved to the other mitigation measures. And that's had the same in SW08. There have been what was in SW08 has now moved to 10, and we've got the cross-referencing happening. When we get to SW09, which is our Sediment Erosion and Water Quality Management Plan, again, we are putting the cross-referencing to SW10, which we finally will get to, which is the flood and hydraulic surface water modelling. And so that requires that to be done up front. And you can see on the top of that page at the end of SW09, we've got the requirement for the Sediment Erosion and Water Quality Management Plan to provide for a baseline water quality assessment to be undertaken prior to commencement of construction. So that means we've got an upfront obligation in the Sediment Erosion and Water Quality Management Plan to do the baseline water quality assessment, which can then be used in the other mitigation measures. And in SW10, we've got the flood and hydraulic surface water modelling to be done upfront, and then that can be used to inform the other mitigation measures. GW01 has been amended. GW01 was written as an absolute prohibition on turbines where there was an inferred depth to groundwater of less than 6 metres below ground surface, which is clearly not what was intended, because GW02 then deals with what do you do if you do have shallower groundwater. So that's been updated just to give GW02 work to do. And then there are in GW05, this was again a discussion between Member Joyner and Dr. Fawcett in relation to the need to consider groundwater contamination, groundwater to have an obligation in GW05 for groundwater contamination management to have regard to the water quality monitoring that's been done under GW06. And so that's what we've included there. And I think that is it for the water. Yeah. So I think we'll be hand over to Mr. Wright.
Yes, thank you. So the next set of changes relate to the landscape character and visual amenity mitigation measures. Similarly, I won't take you to the phasing changes, but you'll see that we've had a close consideration of all of those for each of the mitigation measures and made changes as we see appropriate. In relation to LV01, two changes that have been made. One is to specify the particular sections that Mr. Hark had identified as the key public view locations, and you'll recall that this was addressed in his primary evidence statement in response to the committee's RFI number 37, which you'll find on PDF page 162 of Mr. Hark's statement. The second change is to address something arising out of Mr. Hark's oral evidence about the need to maintain planting for a period of 3 years. So we've inserted that into LV01. When in submissions, we'll say more about the appropriateness of this mitigation measure as a proportionate response to visual impacts, addressing matters raised by you, Member Kirsch. And LV02, we've just clarified through the heading that it's directed to off-site as opposed to on-site through the project area landscape screening. That's the opt-in for affected residences. We've given some considerable thought to how best to describe those by reference to the relevant Appendix L, Figure 30, which you'll find in the Appendix L identifies the particular residential numbers around the project area. And on the left-hand side of that image, which I can show for you, if I zoom in, you can see each of the residences identified in this location here. It's 1, 3, 4, 6, 8, and 10. And because each of those residences has been identified both in the LCVIA, but then as refined by Mr. Hark as those only residences that have the moderate high to high, it seems to us that it's really specifying those residential numbers is all that's really required to trigger the offering of the opt-in, which is required by this mitigation measure. You'll recall I hesitated when looking at that mitigation measure about the reference to the quarry in this location, so we have taken it out and we've moved it down to LV03. The deletion in the middle of that, which was from the day one, is just to put the reference to the residences in the right place in the chapeau of the measure. You don't need to say it again in the middle. LV03, as I've just indicated, we've moved the quarry buffer requirement into that, which is the development of an on-site landscaping plan to screen substations, buildings and lower infrastructure. We think that would capture the quarry appropriately. The second addition we've made is to implement an implementation requirement for the on-site landscaping to the satisfaction of the RA, which is wording we've just taken directly from LV02 in respect of the off-site and it seems sensible to include it also for the on-site. Now, those are the only changes that we've made to the landscape mitigation measures. We haven't made any changes to air quality. And the next point I need to take you to is to the transport measures, which you'll find from PDF page 53. We've also made no changes to noise as I go through. What I wanted to say about the transport mitigation measures, we haven't made any changes to the day one mitigation measures. Member Kirsch, your question about the reconciliation between the DTP condition requests, Ms Dunstan's analysis, and then how we'd address them. We've been through that over the course of yesterday to be clear that we have made all of the changes that Ms Dunstan agreed with. And in fact, on my reconciliation, there was only one material point of departure between what the proponent had put into the day one and what the DTP had requested. There's some adjustments about references to the relevant road authority where we say DTP just got it wrong. The material departure was in relation to a request that DTP had made for traffic management measures during operation of the project. And you'll recall that Ms Dunstan's evidence is that the operational impacts are so immaterial that you just don't need to do anything. It's 14 vehicles per day. So that's the one that we think is the material departure, but it's material for a good reason. So that's all I wanted to say about that. Although I should say that the exercise of doing the reconciliation, particularly where the changes have been made to TP02, is a challenging exercise because of how it's structured. So we've done it carefully, and we hope that we've have clearly enough identified for you where and why the changes have been made in that document 387, I think the number was. Now, the next set, I think, is related to social, so I'll just hand back to Ms Guild.
And I actually skipped cultural heritage inadvertently, so I will go back and do that. So in relation to, gosh, that's hard to read, isn't it? Aboriginal cultural heritage, the plans that I understand Member Kirsch queried the inclusion of have now been included. And so you can see there's consultation in relation to the native vegetation plan, the acid sulphate management plan, peat management plan, noise management plan, and the landscape and visual, the public view locations. I think there's some doubt internally about whether the Goodnich Mering traditional owners want that level of consultation, despite the submission, but it's easy enough to provide for the consultation and then work out what consultation looks like with the traditional owners over time. The AH03 has been amended to include the clarification that Mr Feldman noted, which was that the exclusion zone avoidance provisions relate to sites that were registered before the assessment document was prepared. Clearly, the Cultural Heritage Management Plan, once prepared, will then include a whole lot of other exclusion zones for any cultural heritage that has to be protected, that's identified and has to be protected as a result of that plan. Let's move through those two. So in relation to socioeconomic, we've included made it clear that the community engagement strategy has to be prepared prior to commencement of construction. Obviously, it'll be implemented through all phases. In relation to the shared benefits strategy, there is some additional detail in relation to the neighbour benefit plan, which Mr Weston supported in evidence. The evidence or the questions were along the lines of whether it was sufficiently clear what the neighbour benefits plan was going to provide, and so that additional detail has been provided. In terms of the workforce accommodation management plan, the change has been made there to correct the reference to 1A, 1B and 1C to step 1. As we've set out there in the note, there was discussion about, during Mr Weston's evidence, about whether the expanded version of step 1 that was included in Mr Weston's expert witness statement should be included here. Mr Weston said he was happy enough for the words to be included because he'd written them, but at the same time, it had been put forward as an example, not as something that he said had to be adopted in full. And Owen submits that the more detailed version is neither necessary or desirable in this case because the sub-actions are captured by the overarching action to consider implementation of practicable demand reduction measures. And there's also an element of just putting in a requirement to do things that no one knows what the answer is going to be. And so in terms of a requirement to try and avoid seasonal peak periods and those sorts of things, the construction timetable is going to be dictated by the normal staging requirements about when things are delivered, and in this case, the biodiversity constraints, which are quite significant in some areas with the Brolga buffers and but not just Brolga buffers, also when HDD can be done, you have to have certain conditions, when surveys have to be done, pre-construction, those sorts of things. So the more detail would just be putting in a series of steps that would be completed very quickly by saying can't do it. So that's why that one has not been made, I think. Oh, and in terms of the Aboriginal participation plan, interesting going through Member Kirsch's exercise of phasing and realising that we didn't have an implementation obligation here, so we've included that. And then a series of clarifications around timing of these matters. I'll check my list, and that is that's the end of the. Is that the end of the mitigation measures? Nope. No.
There were no changes to the EMI related mitigation measures. There's a couple of changes. One change to the aeronautical, and then a number 2, the bushfire. And in relation to aeronautical, it's A103, about the Met masts. And you'll recall in Mr. Jennings' presentation, he included a markup with some additional recommended changes for A003, which we've adopted in the yellow. If one was to carefully observe the language used by Mr. Jennings, we've made some minor grammatical changes just for consistency purposes, but nothing to the substance of the changes. And the final set, as I've indicated, is bushfire. And you'll recall, committee members, that in the presentation of Mr. Potter and Mr. Taylor, they indicated their preference for some reordering of the bushfire mitigation measures to align with the CFA renewable energy guidelines. So what we did after they concluded their evidence was to ask them to provide us with a markup of the bushfire mitigation measures, and we've adopted those changes into the Day 2 document. There's a little bit to be explained in terms of the colour coding. So as with all of the others, we've highlighted where there's a Day 2 change. Where there's a Day 2 change that is underlined, it's new drafting as opposed to simply reordering. That's been suggested by Mr. Potter and Mr. Taylor. My understanding about these changes is that either it comes out of their evidence, such as consultation with the plantation operator and the annual or triannual three-yearly updating of various plans, and otherwise they've suggested moving various components of the Day 1 version into different locations. So where there's underlining, it's new text. The red strike through is deleted text. And I'll give you an example. If we're to go down to BF04, you can see there's highlighted text that isn't underlined. That's where we've simply moved existing text to a new location. So they've sought to streamline the measures into sort of the flow that they think is the way that these measures ought to be considered. So that's the colour coding. If I take you back to 01, I won't take you to the minor textual changes that have been made, really the clarity type changes. And what they have inserted, if you can see the first dot point, is that the CEMP be informed by the outcomes of the risk management plan fire safety study. Now that the latter terminology is a new plan or an adjusted plan that they've recommended be included, which has attributes of all of the other plans that were already in the document, but this is the reordering point. We've given a definition for the CFA guidelines, new final dot point about appointment of a person who will provide support to incident management during bushfires. And then at the end of that clause, you can see the preparation of that plan to be informed by consultation with the plantation operator to ensure consistency. That was really to a question, Madam Chair, that you put to the experts, which was agreed with. And then nothing to BF02. BF04, you'll see, if I scroll down, was previously simply in red strike through about a fire danger period. We've just reused that number, and this is where we now find sort of the main bulk of the risk management plan and fire safety study to be developed in consultation with the CFA and finalised prior to construction, and then the various measures that have been taken from the day one and placed into this consolidated plan. And the underline that you can see in the second dot point about the camera, that was day one drafting, to be clear. So that's not a new change, that remains a day one change. Otherwise, you can see there's no additional drafting. They've just changed the type of plan and where it sits in the document. BFO5, you can see for the operational management plan, that it's to be informed by the outcomes of the plan we've just looked at. So the risk management plan and fire safety study. There's a reference again to the CFI guidelines. And then at the end of that, if you can see where the little hand is, where it says induction and other recommendation, that should be a comment. So those 2 dot points are not to be taken. We'll provide a revised version of this. This should have been in a comment in the document, not textual changes. And the last 2 dot points are existing from one of the earlier, I think, in fact, the original mitigation measures, so that's not new text. And then again, this is the annual review that was discussed in oral evidence of the OEMP, and that it also be informed by consultation with the plantation operator. And then almost finally, the fire management plan is to be informed by the CFA guidelines, and you'll see as we've inserted as amended from time to time. That's in the ballot. Throughout this, the bushfire measures, we've indicated that would be as amended from time to time in respect of that guideline. You can see all of the highlighted text that's not underlined. That's just been taken from other measures, reordered. You can see that the FMP is to be reviewed every 3 years as opposed to annually for the emergency management plan, and updated as appropriate. And then BFO7 has been deleted because all of its components are now elsewhere, and the same for BFO8 and the same for BFO9. So overall, the measures have been simplified, but the content remains elsewhere in the reordered and revised measures. So subject to that comment issue, we'll have that corrected and recirculated.
Mr. Wright, just a question. Sorry, don't want to interrupt you.
No, please, Madam Chair.
A question of clarification. So you just used the term OEMP, which is obviously used in, that abbreviation is used in a different context
Yes.
as well. So I just wanted to make note of that if you are making some revisions to that, to perhaps look at the abbreviation.
Certainly, we'll do that.
The other one that I've noted with I think it was BF01, the construction emergency management plan is introduced. One of the highlighted text at the bottom of the first page in that box just uses the term EMP.
Yes, that's
right. Just again, if you're using CMP, so there's various versions of the EM. So
it's a fairly busy day yesterday,
yes.
Madam Chair. We might do a thorough look at all of the defined terms in this document and make sure that they're firstly consistent and don't conflict to other mitigation measures.
Thank you. Yes, I think that would be of value.
Now, that's the totality of the changes in the day 2 EMF. Whether Mr. Chessel wants to go straight to the incorporated document, in which case I'll retain the microphone.
Unless the committee has any questions of us about any of those changes.
I think we're happy for you to continue. We'll ask questions of clarification along the way as we need to.
Yes, please do.
Obviously, happy, for you to just keep going.
Yeah, thank you.
Oh, you do have one question? Yes. Do you want to just pop your microphone on? Sorry, one question here from Member Wilkinson.
Yeah, look, it's just a minor clarification, and it's in BD 11, the Australasian bittern. The text talks about the substation and what will be done in the substation area. The following paragraph then says a pre-construction survey will be conducted in December, January, February, March and April to confirm breeding has finished. Is that specifically in relation to the substation site?
No.
That's a general one, is it?
Yes.
Okay.
Yes. So to the extent that there are, the first paragraph deals with any works within the buffers, and the pre-construction survey applies to those works.
Yeah. Okay. Right. Thanks.
But we can put that on our list of things to consider whether that needs clarification with a paragraph having been inserted in between.
Yeah. That's why I wasn't quite entirely sure.
Yeah,
whether it was
I
general.
can see. Yes.
Because there are, of course, then some more general monitoring requirements in BD 12. Yeah. Okay. Thanks for that.
Thank you.
Thank you. We'll move to the incorporated document.
Now, thank you. Now, there's only two real changes in the incorporated document to talk about. The first of those is in clause 7.1, and you'll recall some discussion during evidence about how one needs to identify the various figures in the EES documentation for a general in accordance provision. So we've just set those out. It's consistent with the relevant tech note that we provided. I can't recall the tech note number, but the one that was dealing with the coordinates, etc. And the relevant figures are figure 3.2, 3.3 and 3.4, which are in chapter 3 of the EES. That's for the overall layout. The main underground transmission line route through and across Boiler Swamp Road, and then the quarry layout in figure 3.4. And then B in that clause references figure 6C4 of Technical Appendix C in relation to the central overhead transmission line option that the proponent is preferencing, which is to that area to the south of Hedditch Hill. So we think those are the four plans that are most appropriate to refer to for the IAC's purposes. And then you'll see just below that in the final markup, we've included a requirement that the development plans must also respond as appropriate to any design changes arising from the Minister for Planning's assessment of the EES to respond to a matter raised by you, Member Kirsch. If I then move over to the micrositing in 7.5, the change that we've made to 7.5E is really a point of clarification. It seemed to us that the drafting that was originally proposed, which was a limitation that micrositing not move a turbine any closer to a turbine-free buffer, hadn't really captured the intent. You've got a turbine-free buffer, that's where you're not allowed to have turbines, but there's no reason not to have them move closer. The restriction should be not having them move into a turbine-free buffer. So we've just sought to make that a clarification on review and reflection of that, of how that would operate. And I don't think there's any other changes I need to draw your attention to. One matter which I'll just briefly address now, and you will have seen has been addressed in the written submissions, relates to the Glenelg Shire Council's request that enforcement of the incorporated document be a matter for the Minister for Planning as opposed to Council. Now, we haven't sort of appropriately not done in the incorporated document, but you'll perhaps have seen in the written submissions that what we've contemplated is the need for a recommendation from the committee that clause 7201 of the scheme, the planning scheme, be amended to specify that the Minister for Planning is responsible for enforcement of clause, I think it's going to be 4512 for the overlay, SCO, in respect of the Kentbruck wind energy facility. So we've given you recommended precise drafting at the latter part of the written submissions that we'll come to later today. But we've understood that issue. We agree with the council. We agree that it can be a fraught problem interpretively. So we think the best way to deal with it is to be expressed by a change to clause 7201.
Can I just ask whether there's been any discussion with the department about that issue?
I think the short answer to that is there has not been, but we don't think it would be a problematic matter, but those discussions can be had. That's it for the incorporated document and the Day 2 documents.
Thank you. Just in respect of that last matter, Member Kirsch, the answer is no in respect of this particular amendment, but it is our understanding that the department has proceeded on the basis that the Minister would be the responsible authority in respect of both administration and enforcement of the relevant controls. So the change that we are recommending is a change that would remove any doubt as to who it is that is the responsible authority, both in respect of administration and enforcement, in the context of a scheme where there is some room to debate the relevant responsible authority in respect of enforcement of wind farm projects in certain circumstances. So we're happy to engage with the department throughout this process, but we understand this recommendation to be one that's consistent with the department's understanding of who it is that will be the relevant responsible authority. Now, the final part of the exercise is to walk through the table that sets out changes to the BAMP, and I'll ask Ms Gill to address that.
Thank you.
Document 380.
So there's a series of discrete changes to the BAMP proposed. The first one is dealing with the pre-commissioning survey plan, and you'll recall that the BAMP has the pre-commissioning survey plan, which has results that then inform the operational monitoring regime. And so, on reflection, looking at section 7.1, it was very clear that that there had to be some monitoring for the Australasian bittern, but it wasn't clear that that other species might have to be considered as well. So what we've proposed here is that text, and this is very consistent with what's in section 2 of the BAMP and the requirements of the BD12. But the pre-commissioning survey plan must include an investigation of technology available for monitoring and survey, and an assessment of whether the cost of utilisation is proportionate to the benefits of utilisation. It must consider best practice survey methods, the most appropriate locations for survey. It must provide for the use of technology if proportionate, and provide for reporting generally in accordance with the relevant requirements of section 12, adapted to be a pre-commissioning context. And we've also included here some text about assessing proportionality, which is one of the matters I mentioned when we were going through the mitigation measures. And so we've included a list of the things that would be considered in deciding whether or not the use of technology is proportionate in the context of monitoring. And so we've said regard should be had to the cost of the technology, the effectiveness of the technology for monitoring species of concern, the extent of risk or impact to the species of concern, the level of uncertainty about that risk or impact, and the availability, costs and effectiveness of other methods of survey and monitoring. So we say that they're all matters that should be considered in deciding whether or not it is cost effective to, deciding whether or not it is a proportionate response to use technology. And we do want to make the point here as well that we don't, there's no expectation of needing further monitoring at this stage, other than most likely in relation to Australasian bittern, to establish, if nothing else, the quantification for an offset if an offset is required. There is plenty of information, a wealth of information about most of the species of concern here. So this is, but this is consistent with the commitment to making sure that the best information is available and that an adaptive approach is taken. But it doesn't mean that there will be a whole lot of pre-commissioning surveys required. The second point in this table, deals with Brolga. One of the matters that came up during evidence was that the BAMP doesn't deal with Brolga monitoring in any detail at the moment. And there was a discussion about the fact that this sort of monitoring can go in the Brolga monitoring and compensation plan, or it can go in the BAMP. And Neowen doesn't have a view about where it should go, but for now we've just made it the most important thing is to make sure that the documents talk to each other, and at the moment we've just put in a footnote to clarify that the monitoring of Brolga, that the details will be included in the Brolga monitoring and compensation plan. That could obviously go the other way. Point 3 is providing some additional detail about what to do once the pre-commissioning surveys are done. There's a very short, this is really a long version of a paragraph that's already in the BAMP, and it requires that the updated BAMP must include an investigation of technology available for detection and curtailment, and require, if appropriate, having regard to various matters, the use of that technology. And we have here again some points for dealing with and assessing proportionality. Now, these are not the exact same points as we had in relation to assessing the use of technology in a monitoring context, because once you're talking about using technology in an operational context, you're starting to talk about curtailment. And so this includes the impact on energy generation from the implementation of technology. And one of the matters that we've addressed in the written submissions is, that this is not an irrelevant matter. What the impact on energy generation is from curtailment to avoid impacts on birds. And it may be that curtailment is required, but before that decision is made, the impact on energy generation is a matter to consider. And that text just makes that very clear. So point 4 deals with the need to update some of the harvesting data. We realised after the BAMP had been put in that there were some inaccuracies in how, in what type of operations will happen when. So that's just the update to the tables and figures. Section 5 and 6, or sorry, lines 5 and 6 in this table. So it's annoying that they split over a page here, but they both deal with a matter that I addressed you on in terms of the objective of the BAMP being about ensuring that there are no significant impact on on species of concern, threatened birds and bats, rather than no bird deaths at all. And some of the language in the BAMP is very focused on getting below a trigger level, avoiding impacts, and we've taken out that sort of language and said not, and brought it back more to that objective of avoiding significant impacts. And it's clear from things like the collision risk modelling that's been done that the expectation and requirement is not 0 deaths. It is ensuring that there is no significant impact and taking proportionate responses to those impacts. And so that's what 5 and 6 are proposed to do. Row 7 deals with where does the $50,000 penalty for a southern bent wingbat second fatality, where does that $50,000 go? And we've said that it goes into the recovery fund, the ecology fund. We still have a little bit of work to do to get our terminology consistent on what we call this fund. But the fund that's described in BD 15, which has the money going in every year, and so the $50,000 would go into that fund, but it would only be able to be spent on southern bent wingbat. So generally, that fund can be spent on the species considered most appropriate, but any penalties sort of applied under the BAMP would only be able to be spent by on the BAP. We thought, given that there's a fund that exists and will have the administration and oversight arrangements in place, it made sense for that money to go to that fund. Sections 8 and 9 are just some minor updates reflecting the way that the BAMP has been restructured. And then Sections 10 and 11 are both directed to ensuring that the requirements of BD 12 are properly implemented and that there's timely and appropriate provision of information about monitoring. And so says that annual reports must be made publicly available on the project website within 2 business days of acceptance by the RA and DECA. And so that information will become promptly publicly available. 11 deals with data requirements, and this goes to some of the matters raised in the post-construction monitoring reports about inconsistent data sources. So this text has been taken from BD 12, I think originally was from DECA. If DECA has different requirements, they can obviously let us know what they are, but the intention is just to make sure that the data that is collected and provided is useful and consistent, presumably, with other wind farms, but we can't control that. That's up to DECA. Row 12 requires the completion report, which is required by BD 12. So when you get to the end of the monitoring period, you have to do this report that will then be considered by DECA to decide, and the responsible authority to decide whether or not further monitoring is or other actions are required. And row 13 is a new section 14, which just confirms the ability to amend the BAMP and also to confirm the role of the independent environmental auditor. And this is something that's taken from BD 12, but also has been slightly amended to include specific timeframes for review by the auditor. So we've got reviews within 6 months of full commissioning and then every 2 years from that point. And also a new addition, which is that any recommendations from the auditor for changes to the BAMP must be implemented into the BAMP subject to the authority signing off. And the final change is one that has to be made throughout. It came up in evidence, I think, in response to questions from DECA, that the BAMP deals quite comprehensively with turbine collisions, but less comprehensively with the potential for overhead power line collisions. They've been included in the collision risk monitoring and those sorts of things, and we've got a mitigation measure about them. But there is a need to ensure that the monitoring regime does deal with the potential for overhead power line collisions as well. So that requires changes in quite a few points, but that we've captured it there as a general point. So were there any questions about the BAMP changes?
No questions. Thank you.
Well, Madam Chair, I indicated a moment ago, or at the start of the day, that there were 2 things that we proposed to address. I'm not sure I indicated what the second was, but you will no doubt appreciate the second is to address the written submission and walk you through that. I'm mindful of the time and whether it might be that the committee wanted to take an earlier break than normal.
I'm happy to continue until our scheduled break.
Okay.
I'm conscious people are probably observing online as well and maybe planning around those breaks. So, yeah, we'll stick to the time as much as possible.
No problem. I'll invite you to indicate when you'd like me to break. That's no problem at all. Before I do turn to the written submission, though, I did just want to emphasise that we wanted to undertake that exercise, that is the walkthrough of the Day 2 EMF incorporated document and BAMP changes at the outset for a couple of reasons. Firstly, because sometimes these exercises are left to the end of the day and I think it's beneficial to do it while everyone's mind is fresh. But secondly, to demonstrate that this is a proponent that is actively engaged in this process and a proponent that is responsive to the recommendations given by its independent expert consultants. And what I hope is apparent to the committee is that the changes that have been introduced into the EMF in particular are changes that give effect to the particular recommendations that have been made by the consultants along the way. That is, at each step of the process, from the exhibition of the EES through the review of those mitigation measures as part of the suite of expert evidence reports as worked into the day one set, and as further refined in evidence, that is before you and testing, what one sees is a very clear preparedness on the part of this proponent to respond to expert advice as to how the relevant mitigation framework should be structured so as to ensure that it operates effectively. And of course, it's important in the context of the IAC's overall assessment to have confidence in the robustness and comprehensiveness of the EMF. And in our submission, having undertaken that exercise, the committee should recognise the extent to which the EMF responds to the evidence that's been heard before the committee. I do note also that one of the tasks that remains with us is the preparation of the table of, or the reconciliation of, how it is that expert recommendations have been given effect throughout the course of this process. And as I understand it, that's to be submitted at the end of the process. But what I can readily anticipate is that that table will demonstrate the very significant extent to which the recommendations provided by the independent experts have been given effect explicitly through changes to the EMF. Okay, I'd like to turn now to the written submission. And I don't have that document number immediately to hand, but 386. What I'll do is ask the committee to have that document open before it. I'll be speaking to the document rather than reading through the entirety of it. But there are some parts that we wish to emphasise. There are some parts that I'll seek to expand in oral submissions. And there'll be some parts that we seek to simply have taken as read. If the committee has that document, I'd like to start, please, at PDF page 4, where we set out some introductory matters. And at paragraph 2, as the committee can no doubt appreciate, this is a document that we've drafted with a view to it being read with the other submissions that have been filed. That is, my client's Part A submission, my client's Part B opening submission, and the various topic-specific opening submissions that have been filed along the way that we've listed under paragraph 2. And at paragraph 3, we note again that each of those topic-specific submissions include a list of the relevant documents, the relevant materials that bear upon the particular topics that are addressed, including, in each case, the relevant evidence, technical notes and other materials that have been filed on behalf of the proponent. At paragraph 4, we note that in accordance with the committee's directions, we anticipate filing reply submissions, that is at the very end of this process. And I can indicate that our intention is that those submissions really be framed as a true reply, that is to respond to matters raised in the submissions of other parties. And it may well be that to the extent that we feel those matters have been adequately addressed elsewhere, that we won't repeat matters in that reply. What we've done in these submissions, as you'll see in paragraph 5, is structure them into 4 parts. The first part deals with the relevant statutory processes that must inform your advice to the Minister. The second part really is the bulk of the submission, and that deals with certain matters that have arisen from evidence. The third makes some observations about the Day 2 documents, and the fourth sets out some concluding remarks. If we turn then to the first of those parts, Part B, we set out here some observations about the various statutory processes, and we first make the observation that throughout the submissions we've delivered to date, we've sought to emphasise the need for the committee's assessment to be structured and objective. That is, structured having regard to the relevant decision-making criteria and the evidence before it. And in the Part B submission, in the opening submission that we delivered on the first day of the hearing, we addressed the statutory criteria in respect of climate change. What we do in this section is address the relevant statutory frameworks more broadly, that is, as they concern the balance of the matters that need be considered. The first legislative framework we address is that established under the Planning and Environment Act, and I'm well aware that this committee understands how that framework works and the relevant decision-making principles that inform an assessment. And what we do at paragraphs 8 and onwards is address the concept of net community benefit and acceptable outcomes. Again, concepts that I'm sure this committee readily understands, and I won't labour. We do make reference at paragraph 9 to the notion of net community benefit being directed toward acceptable outcomes as opposed to ideal outcomes. As this committee will no doubt be aware, a decision of Justice Osborne of the Supreme Court in Rosen and Macedon Ranges Shire Council explains how it is that concept should inform planning decision making. That is, that certain negative consequences don't preclude an overall net community benefit being achieved. And I won't take you through that relevant passage. At paragraph 10, we make reference to the decision of the Court of Appeal in Boroondara City Council and 1045 Burke Road, which affirms that commentary. What we do want to emphasise for present purposes, though, is what we've addressed in paragraph 11. And in our submission, it is notable that in the context of a planning scheme amendment process, as opposed to a planning permit process, the relevant test involves a series of broader policy considerations than would apply in the context of a planning permit application. And what we say in the second sentence is this, that unlike in the case of a responsible authority that's assessing a planning permit application, the task of the planning authority, to which this committee must provide advice, is not to determine whether the proposed amendment would implement or give effect to the existing provisions of the scheme. It's instead to have regard to the existing provisions of the scheme, including the relevant policy framework, amongst a range of other considerations in determining whether the proposed amendment would itself advance net community benefit and sustainable development for the benefit of present and future generations. And so if we pause there, members of the committee, we're not here dealing with an exercise of statutory planning where you are assessing whether or not a particular application conforms to the terms of the scheme as it is presently framed. Instead, we're involved in a process of strategic planning wherein this committee need consider whether the proposed amendment to the scheme to facilitate this project would give rise to acceptable outcomes having regard to a whole range of factors, including relevant provisions of the scheme and considerations of net community benefit and sustainable development. Now, before I move on to the next submission or next part of the submission, I did just want to elaborate on how it is we say these matters are particularly relevant to the matters that are raised in the committee's terms of reference. And In particular, we wanted to raise this at the outset because of its implications concerning how it is the committee should approach its assessment by reference to the particular scoping requirements and evaluation objectives. And perhaps to give some substance to this issue, or some context to this issue, what I wanted to do is take the committee's assessment of visual impacts as an example of how it is these notions of net community benefit, sustainable development should bear upon an assessment of this project pursuant to the relevant scoping requirements. And the reason why I've chosen visual impact is because of all the statutory processes that are at issue here, it's the decision-making framework under the Planning and Environment Act, as opposed to, say, the EPBC Act or Environment Protection Act or the Flora and Fauna Guarantee Act, that bear most directly upon the consideration of those types of issues. So when the committee comes to consider, for example, the acceptability of impacts in the nature of visual impacts, it must be assessing that question under the framework established under the Planning and Environment Act. That is, under the framework wherein this balancing exercise that is explicitly called up, where the committee must balance competing objectives in favour of net community benefit, are at large. So at one point in the hearing, Member Kirsch asked us a hypothetical question about the impact of the project on views from Lake Monbiong, the impact on amenity, impact on utility of the campsite and the like. And the particular question was premised on a scenario where the committee considered the visual impact on that location to be unacceptable. So that was the premise of the question that we were to respond to. We're going to come to address the merits, if you like, of that premise. That is, we're going to come to explain why, in due course, in our submission, the committee should not consider that the visual impacts are unacceptable. But what I wanted to emphasise for present purposes is any decision about unacceptability in this context can only be framed in the context of the broader assessment of effects under the Planning and Environment Act. That is, there are no other statutory processes that allow the committee to reach a view about acceptability other than those that exist in respect of or are established under the Planning and Environment Act. So in order to conclude that the visual impact, for example, of this project on the Lake Monbiong campsite is unacceptable, being the premise of the question, the committee would have had to have undertaken the balancing act called for under the Planning and Environment Act, and having undertaken or completed that assessment, reached the view that is unacceptable. That is to say, there's no separate independent statutory marker of what would be considered acceptable in this context. And as we'll come to explain, in this case, there are various factors that would count against any conclusion of unacceptability. You have before you the evidence that demonstrates that the extent of visual impact for much of the national parks is limited. You have before you evidence about the relevant zoning that applies to the parcels of land, that is the PPRZ that applies to the national park land, that is the Discovery Bay Coastal Park, the farming zone that applies to the subject site and the relevant expectations that that creates. You have before you evidence about the fact that this is a campsite with variable levels of patronage over the year, a transient population as opposed to a fixed permanent population, as would be the case of impacts in respect of private dwellings. You have before you evidence about the extent of change and that one's reaction to that change will be subjective. These are all things we'll come back to address. But the point that I really wanted to emphasise in opening, as it concerns the framework established under the Planning and Environment Act, is that any assessment of the acceptability of those visual impacts must be undertaken having regard to the public benefits of the project. And it's a feature of this type of decision making under the Planning and Environment Act that localised disbenefits need be balanced against a series of high-level, broad-based, very significant public benefits that are derived from this type of project. And again, we'll come to those matters shortly. But in this case, it does require an assessment of localised disbenefits, which we say are themselves relatively limited and should be considered acceptable in the context of a project that delivers such massive public benefits expressed in all sorts of ways, but it can be simply put as a project that has the capacity to deliver up to 5% of the state's electricity under current demand scenarios. That is to say, again, when one comes to consider acceptability, it cannot be considered in isolation. It must be considered as part of the overall balancing exercise called up under the relevant Planning Act. And so, members of the committee, when you come to consider the scoping requirements that apply to this project, and for example, whether this project adequately minimises visual impacts on locations, including upon the national park, that assessment must be undertaken having regard to the governing decision-making frameworks, which in this case are the Planning and Environment Act. So really there I've isolated one factor to demonstrate the point. Obviously, the nature of the balancing exercise is far more complex than that. There are a whole series of countervailing considerations at play. You've heard from Mr. Glosser. We rely upon his evidence. But we did want to make that point in opening that these issues need properly be assessed in totality, having regard to the relevant frameworks that govern the ultimate decisions to be made in respect of this project. Now, Madam Chair, is that an appropriate time to break, or would you like me to keep going?
Perfect timing to break. Thank you.
Thank you.
So we'll break for 15 minutes and we'll see everybody back shortly. Thank you. Great. Thank you, Mr. Chessel. I'll hand back to you.
Thank you. I'm back in the written submission at PDF page 6. The next topic that we address in respect of the framework under the Planning and Environment Act are the recent amendments that have introduced specific requirements for consideration of the achievement of Victoria's renewable energy generation targets and greenhouse gas emissions reduction targets. I've set those out at paragraph 12. You'll recall that this is a matter we addressed in our opening submission. I won't spend a great deal of time addressing that again today. At paragraph 13, we identify that the amendments were made recently to the Planning and Environment Act that call up specific regard for the emissions reductions targets that, of course, operate in tandem with the renewable energy generation targets that we referenced in paragraph 12. In paragraph 14, we make specific reference to the amendments to section 12 of the Planning and Environment Act. They are amendments that I took you to in opening. They explicitly require a planning authority to consider those targets. And what we've done to supplement that submission or provide further context is make reference to the second reading speech of the Climate Change and Energy Legislation Amendment Act, which was the Amendment Act that introduced those changes into the Planning and Environment Act. And you'll see at paragraph 14 that we have an extract set out there. I'll focus on the second and third paragraphs of that extract. And what that commentary explains is the bill will add Victoria's climate change goals to the objectives of the planning framework established under the Planning and Environment Act to expressly integrate climate considerations into our planning framework and the decisions made about the use and development of land across our state. The new objective will form part of the objectives to be considered when municipal councils come to review their planning schemes and indeed when a minister comes to amend a planning scheme. These amendments will also introduce a new head of consideration for planning authorities, including local councils, to consider climate change when preparing a planning scheme or planning scheme amendment. And I suppose if we pause there, members of the committee, it's not that matters relevant to climate change or relating to climate change weren't relevant to planning decision making prior to these amendments, but what these amendments do unambiguously is put front and centre considerations in respect of climate change as headline issues for planning authorities to consider when they come to assess the merit of amendments to planning schemes, which of course this process in part involves. And again at 15, I appreciate that nobody on this committee would need any persuading that climate change poses existential threats to various aspects of our way of life, but it's affirmed by the relevant introductory passage to the second reading speech that I referred to a moment ago, where the following was said: the Victorian Government recognises that climate change is one of the most critical issues facing us today. Both the science and our lived experience in recent years in Victoria tell us clearly that sustained and ambitious action to reduce greenhouse gas emissions is essential to avoiding the worst impacts of climate change. Sustained and ambitious action is what is called for and what is seeking to be promoted by the type of change that has been introduced. And so at paragraph 16 of our written submissions, we suggest that really these amendments mark the commencement of a new era of consideration of climate change and emissions reductions targets. And by that, I suppose we mean an era whereby the Act requires explicitly consideration of not just climate change generally, but more particularly the achievement of particular reduction targets explicitly. And we note that, as far as we're aware, this committee will be the first to consider these provisions, or at least certainly to consider them in relation to a project of this type. That is a project that has the very clear potential to make a material difference to the achievement of Victoria's emissions reduction targets. And so in our submission, the committee should place significant weight on the project's potential to materially contribute to the achievement of the legislated emission reductions targets. That is beyond doubt in our submission, and by doing so to contribute to the amelioration of the impacts of climate change. Now, at paragraph 17, we make reference to the complementary provisions of the planning scheme that give effect to or supplement those recent legislative changes. And what I'd like to do for present purposes is focus on the clause 01 change. And I wanted to do that because I reckon I've picked up a planning scheme, I don't know, 1,000 times, thousands of times, tens of thousands of times, who knows. And every time I picked it up, I don't think I've ever focused particularly on clause 0 or clause 01. And in preparing these submissions, I thought that it's something that I should do. And I'm going to share my screen. And this is the Glenelg planning scheme. Clause 0 of the Glenelg planning scheme sets out the purpose and vision. And it says this section sets out the purpose of this planning scheme and the vision and strategic direction for the municipality. Clause 01, purposes of this planning scheme. What one sees are that the purposes are to provide a clear and consistent framework within which decisions about land use and development of land can be made, to express state, regional, local and community expectations for areas and land uses, to provide for the implementation of state, regional and local policies affecting land use and development. So 3 fundamental components of what the planning scheme does. And what is the 4th fundamental component of the planning scheme? What is the 4th purpose that it is to serve? It is to support responses to climate change. And I suppose I wanted to emphasise that in opening or as an introductory matter, because one shouldn't lose sight of the fact that a planning scheme is a form of delegated legislation. It's an instrument that must be construed having regard to its text, context and purpose. And here what we see is the explicit stated purposes of the scheme as a whole include now to support responses to climate change. It is, in our submission, a marker of the extent to which these issues should properly inform not just the interpretation and application of the scheme as a whole, but they should inform how it is a decision maker goes about weighing competing interests at play in respect of applications like this, and how fundamentally important, that is, the extent, the nature of the weight that a planning decision maker should attribute to the benefits of a project like this that, on any view, materially responds or supports the response to climate change. That is, by implementing and advancing the achievement of Victoria's emissions reduction targets. Now, stop sharing. The next section of the submission I'm happy to take as read. We've made some observations about the Flora and Fauna Guarantee Act. In short, that is an act that requires that certain matters be taken into account in respect of the decision-making processes that are at issue before you. Those matters are matters that are adequately or at least addressed comprehensively by a consideration of those planning policies that call for the protection of biodiversity. We've made reference to those provisions. The key point that we wish to emphasise for present purposes is that in undertaking the assessment of environmental effects under the Environment Effects Statement, the authors of those reports have been very conscious to properly articulate and identify those values that are the subject of protection or the subject of consideration under the Flora and Fauna Guarantee Act, and have provided commentary in respect of how it is this project responds properly and protects those values. The next matter that we address in the written submission at PDF page 10 are the native vegetation guidelines and the assessor's handbook. And again, I won't walk through this section in detail. You've heard the evidence of Mr. Gibson and Mr. Organ as to how it is that this project responds appropriately to the three-step approach that is really the touchstone of the guidelines, that is to avoid, minimise and ultimately offset. And we rely upon that evidence in those regards. At paragraph 26, we note that one of the documents, one of the many documents that have been amended either shortly before or during the course of this committee hearing process is the Assessor's Handbook. And we note that that update, that is the update to the Assessor's Handbook, now picks up a reference to the update to the relevant Australian standard that concerns tree protection provisions. And we've stepped through those matters at paragraph 26. The key point is that there is no change of substance to the approach under the new handbook. That is, the metric utilised is the same. It's expressed in different terms. So instead of referencing a tree protection zone, there's a reference to the notional root zone, but those two zones are calculated in the same way under the new Australian standard, and the 10% threshold has been retained in the Assessor's Handbook. Notwithstanding that, under the new guideline, that is the new Australian standard, I should say, there is a what we've characterised a more accepting approach to encroachment than was previously the case, and we'll come to explain that. So the long and the short of it for present purposes is that neither the update to the handbook nor the update to the Australian standard count against the assessment approach that has been adopted to inform the impact assessment in respect of native vegetation. The next section of the written submission at PDF 11 concerns the Environment Protection and Biodiversity Conservation Act, the Commonwealth Act. And as this committee no doubt is aware, this is a project that requires approval under that Act in relation to its potential impacts on three things, that is, three matters of national environmental significance as defined under the EPBC Act. The first being Ramsar wetlands, the second being listed migratory species, and the third being listed threatened species and communities. And what we note at paragraph 28 is that the relevant decision-making criteria are different depending on which controlling provision applies. What I'd like to do before I turn to the balance of this section is just make some observations about the operation of the EPBC Act more generally. And to that end, I'll share my screen, and I hope that on your screen you can see chapter 2. And what I wanted to do is just walk the committee briefly through those parts of the EPBC Act that govern the exercise of discretion under this Act. I'm just struggling to organise my screen, but I'm under control now. So, sorry. The first part of the relevant statutory process concerns the identification of circumstances in which a proposed action is a controlled action. And what one sees in the description of the simplified outline of the chapter is that this part of the Act provides a basis for the Minister, that is the Commonwealth Minister, to decide whether an action that has, will have, or is likely to have a significant impact on certain aspects of the environment should proceed. And I just want to pause here to make the point that often in these processes, there's a fixation on whether or not a project will or will not have a significant impact. And that's, of course, important under this statutory framework, but it's not the determinant of acceptability. That is to say, a project, an action with a significant impact can properly under this Act be approved. Indeed, the whole system, the whole framework is directed toward establishing circumstances in which an action that does have a significant impact can proceed. And I'll come to flesh that out shortly. So the way the Act works is by prohibiting a person from taking an action without the minister having given approval or decided that approval is not needed. Right? So the way this Act works, like a number of acts, is to preclude and make unlawful the taking of an action that has, will have, or is likely to have a significant impact on certain aspects, that is a controlled action, without approval. And there's an explanation that where approval is not needed to take an action if any of the following have occurred, none of which have occurred here, and there's other circumstances in which approval is not required. But we're in a scenario where approval is required. Part 3 of the Act establishes the requirements for environmental approvals, and as I mentioned a moment ago, there are different matters of national environmental significance that are identified as warranting particular approval. If we take, for example, those provisions that concern wetlands of international importance, Ramsar wetlands, one sees at section 16 the prohibition, that is firstly the prohibition, a person must not take an action that has or will have a significant impact on the ecological character of a declared Ramsar wetland, or that it is likely to have a significant impact on the ecological character of a declared Ramsar wetland. And there's a civil penalty provision, but that civil penalty provision does not apply, the prohibition does not apply to an action if an approval of the taking of the action by the person is in operation under Part 9 for the purposes of this section. So where the minister grants approval, one can undertake a controlled action, even in circumstances where it does have or could have a significant impact on the ecological character of a declared Ramsar wetland. Chapter 4 of the Act concerns environmental assessments and approvals, and of course that's the part of the process that we're presently involved in. It says this chapter deals with assessment and approval of actions that Part 3 prohibits without approval, that is controlled actions. It does not deal with actions that a bilateral agreement declares not to need an approval. That's not our situation here. A person proposing to take an action or a government body aware of the proposal may refer the proposal to the minister so he or she can decide whether his or her approval is needed. And in this case, the minister has decided that approval is required. And a determination has been made about how that assessment should be undertaken. And in this case, the assessment is being undertaken pursuant to a process laid down under a bilateral agreement. And that is, this assessment process informs the minister's decision. Part 9 of the Act then concerns the approval of actions, that is the approval of control actions. And the key point that we want to identify for present purposes is that there are powers on the part of the Commonwealth Minister to attach conditions to any approval. They can be general conditions as set out under subsection 134, subsection 1, I should say. Under subsection A, they might concern protecting a matter protected by a provision of Part 3 for which the approval is effect, or repairing or mitigating damage to a matter protected by a provision of Part 3 for which the approval has effect. That might include the provision of offsets. Under subsection 2, there's provision for the minister to attach a condition to the approval of the action if he or she is satisfied that the condition is necessary or convenient for, amongst other things, protecting from the action any matters protected by a provision of Part 3. The last matter that we wanted to emphasise is that when the Commonwealth Minister comes to determine these applications, the Commonwealth Minister is not bound to simply consider ecological impact alone. Instead, you see that under 136, Section 136 of the EPBC Act, there are a series of mandatory considerations, and a series of factors that may also be taken into account. And the mandatory considerations include relevantly, firstly, matters relevant to any matter protected by provision of Part 3, but secondly, economic and social matters. And furthermore, the factors to be taken into account by the Commonwealth Minister include, amongst other things, the principles of ecologically sustainable development, principles that this committee will be familiar with, certainly in respect of their operation in the context of the planning and environment legislation. Now, the reason why I wanted to walk the committee through that framework, albeit at a very high level, is to make good a series of propositions. And we've set those out at paragraph 31 of the written submission at PDF page 12. And what we say in that regard is that there are several important features of the assessment process. The first is that significance of impact must be established. We note that decision-making in respect of significance is assisted by reference to significant impact guidelines issued by the Commonwealth and, in this case, by Migratory Shorebirds Guidelines, documents that you'll see referenced within the relevant technical studies and evidence statements. Furthermore, that in considering significance, it's necessary to consider any relevant recovery plan, threat abatement plan or conservation advice for the species, and we've sought to bring those to your attention where relevant. Thirdly, that in considering the acceptability of the action, the relevant Commonwealth Minister must properly consider, in addition to ecological matters, social and economic matters. And so again, like under the Planning and Environment Act, that suite of broader considerations targeted in particular at transitions in the electricity market and the economic and social benefits that it will deliver, as well as the environmental benefits, are matters that are properly taken into account. And the fourth point we make is the point that I made a moment ago, which is that a significant impact is not in and of itself unacceptable. Instead, the Minister has the express power to approve actions that would result in significant impacts, and in doing so may specify appropriate conditions. And so paragraph 32, we identify that we have sought, that is the proponent has sought through the relevant plans, through the relevant technical appendices to make reference to the relevant plans and significance criteria, as have the witnesses that have appeared before you. And in our submission, the proper conclusion that the committee should reach is that if we leave Australasian bittern to one side for the moment, none of the protected matters that have triggered the requirement for assessment under the EPBC Act would meet the threshold of significance. That is, on a proper assessment of the material before you, the proper conclusion is that the project would not have a significant impact on any of the other matters that have triggered consideration under the EPBC Act. The one element of the assessment where that matter is less clear is in respect of the Australasian bittern. You recall that the Australasian bittern, the project was assessed as having a significant impact on the Australasian bittern in the technical appendix, that is in the impact assessment recorded within the EES, and that was the view that was expressed by Mr Van Oster. But that Mr Organ expressed a different view in respect of the nature and extent of impact, and his evidence was that he considered the threshold of significance not to be reached in respect of that species. And we'll come to address that further below when we come to talk about the evidence that you've heard in that regard. But I suppose the point that we want to emphasise for present purposes is ultimately there are mechanical consequences of a decision in respect of the extent of impact in respect of the Australasian bittern. That is, in the event that a significant impact exists, there will be consequences in respect of a requirement to provide an offset that may not arise in circumstances where Mr. Organ's view is accepted. So there are those differences, but in our submission, there are not differences in terms of the ultimate acceptability of the project. That is, even if the committee was to consider that the significant impact threshold was reached in respect of the Australasian bittern, the statutory framework under the EPBC Act still quite explicitly contemplates that approval can be granted, and our submission, given the prospect of ameliorating impact over time, of providing offset should that be considered required or necessary, and various other attributes of this project of an economic and social character, there really should be no doubt in our submission that the approval should be granted. Now, the next part of the submission concerns the National Parks Act, and I'm going to invite Mr. Wright to address the committee in respect of the matters that we've set out in this part of our submission. It, of course, concerns a very discrete aspect of this project and a very discrete aspect of the approvals required for the project. That is, the requisite approval applies only in respect of that portion of the transmission line that would extend within and through the Cobbobity National Park, as opposed to any other part of its alignment, including the Cobbobity Forest Park. So unless there are any questions of me, I'll hand over to Mr. Wright.
Happy for you to continue. Thank you.
Thank you, Mr. Chessell. Just to the point that Mr. Chessell's made about the distinction between the Cobbobity National Park and the Cobbobity Forest Park, I'm going to address you now about the National Park component and by reference to the approval that's required. One matter we haven't addressed in the written submissions, but that I'll address you on briefly orally, is an approval that would be required in respect of the Cobbobity Forest Park pursuant to the Forests Act 1958. So I'll come back to that soon. With regard to the National Parks Act approval, I'd like to commence by taking you to the Act, and I'll take you to Section 27, which is the approval or consent section that we are concerned with. And I'd like to make the point first that what Section 27 is directed to, on its terms, is rights of public authorities in respect of national parks. And that's really important here because there's no debate, as it seems to us, as between ourselves and Parks Victoria, that the proponent is a public authority for purposes of Section 27 and both the National Parks Act and the relevant Enabling Act, which is the Electricity Industry Act. And I'm going to spend a bit more time about that concept in a moment, but what we'd like to observe at the outset is that what Section 27 explicitly contemplates as a consequence of the reference to public authorities and the definition of that term is linear infrastructure of this precise type extending through and being constructed within national parks. So we've referred to this in the written submissions as a very clear expression of legislative intention as to what is permissible within a national park environment. And we think this is a very critical consideration when one starts the assessment process in respect of that part of the transmission line that would be constructed through the Cobbobity National Park, is that the Act itself enables those sorts of activities and expressly contemplates that they will occur by public authorities within national parks. And when one steps back from Section 27 and thinks about what that means at a higher level sense, when we're talking about what rights, powers and functions that public authorities may have, including under the Electricity Industry Act, we're talking about generation companies and transmission companies which perform public functions. We talk specifically about a transmission line, of course, for our society to function, we need electricity, and electricity runs through lines from A to B, and you need to put those where they are needed to get to from A to B. And that might be in circumstances like this through a national park. And that fundamentally is what Section 27 is seeking to enable expressly. So there can't be any suggestion, and we don't understand that there will be, that what's proposed is fundamentally inconsistent with the National Parks Act or the values of the park, because the Act itself expressly allows these things to occur. So what you can see in Section 27 subsection 1 is that a public authority may, with consent, perform its functions and exercise its powers in relation to a park in accordance with any conditions that are applied to that consent. So the first point is that we require a consent, relevantly here, of Parks Victoria to do the activities required to construct the line through the national park. Subsection 2 provides a limitation on Parks Victoria granting that consent where the Minister for Environment considers that the performance or functions or exercise of powers may substantially affect a park. And I'll come back to that in a moment, because that's really the critical consideration for the advice that the committee needs to give, which is what is meant by substantially affect a park, and fundamentally whether what's proposed by the proponent would substantially affect the Kobobini National Park. The third component in subsection 3 is that the consent of Parks Victoria can be subject to such conditions as Parks Victoria determines. So once a decision's been made to grant consent, where the Minister is satisfied that the activity won't substantially affect the park, Parks Victoria can impose conditions on the grant of that consent. That's the framework. Before I come to substantially affect, I'll just take you through the analysis in respect of public authority. The place to start is in subsection 2 of section 3 of the National Parks Act, which provides that in this Act, reference to a public authority includes a distribution company, a transmission company, a generation company within the meaning of the Electricity Industry Act 2000. You will have seen in the written submissions we've provided you some detail about this. There's two scenarios that might be realised in respect of the construction of the transmission line, and by whom. If it's the proponent that does it, depending on the timing of the grant of the generation licence that the proponent must hold for the project under the Electricity Industry Act, the proponent might be the public authority that seeks consent under Section 27. Alternatively, the proponent might engage AusNet to undertake the construction activities of the transmission line through the park, in which case AusNet, which holds both distribution and transmission licences under the Electricity Industry Act, would be the public authority for purposes of the consent under Section 27. So there's no question, as we've understood it, that the proponent, whether it acts itself or through AusNet, would be a public authority for purposes of Section 27. But it's important that the committee understands how the regime works, to the point I've just made, at what the National Parks Act seeks to allow public authorities to do. We've understood that the point about the proponent being a public authority has been agreed by the department. Now, the critical question, as I've indicated, is what does substantially affect mean, and will this project substantially affect the Kobobini National Park? This is, in our submission, an appropriate question and matter for the IAC, the committee, to advise on in respect of the approval that's required under this section. And in fact, Parks Victoria, in its submission on the EES, has expressly asked the committee to do so, and we think that's appropriate. Fundamentally, however, the question is a very simple one. We've provided in the written submissions to you discussion of how one approaches interpretation of this question by reference to, as I've indicated, the explicit recognition that public authorities are permitted to do these activities through national parks. We've made reference to dictionary definitions of substantial and affect, but terminology that might be more familiar to the committee is substantial impact as an example, which would be an appropriate way to, or lens through which to look at that question. And we've also referred you to the objects of the National Parks Act, which include, and you'll find the relevant ones set out at paragraph 47 of the written submissions, but I can bring them up on screen for you. And these include to make provision in respect of national parks for the preservation and protection of the natural environment, including wilderness areas and remote and natural areas in those parks, for the protection and preservation of Indigenous flora and fauna and of features of scenic or archaeological, ecological, geological, historic or other significant interest in those parks, for the study of ecology, geology, botany, zoology and other sciences relating to the conservation of the natural environment in those parks. And then if one goes further down in the objects to subsection C, you'll find to make provision in accordance with the foregoing for the use of parks by the public for purposes of enjoyment, recreation or education, and for the encouragement and control of that use. For present purposes in our submission, the critical objects really relate to ecological values by reference to native vegetation and consequently impacts of the project on native vegetation. Secondly, ecological values by reference to flora and fauna. And thirdly, recreational values for the Coboboni National Park. And that includes general visitation through the area and to the area, and more specifically, relevantly, how it's used for purposes of the Great Southwest Walk. Now, you've heard evidence about all of those matters. And if I just briefly touch on them, because you'll hear more about these from Mr. Chessel and Ms. Guild later. But of course, in respect of native vegetation impacts, you've heard the evidence of the relevant experts and Mr. Galbraith about, by reference, including the methodologies that might be employed for the construction of the transmission line, the avoidance of impacts on applejack trees, and the fact that there has been an assumption made about the loss of other vegetation, which is considered to be a highly conservative assumption. And really that must be borne in mind, of course, of the fact that the impact area is very small by comparison to the balance of the national park in respect of the area that would be impacted and the consequential impacts on native vegetation, which itself are highly conservative. In respect of flora and fauna, you've heard evidence from Mr. Organ and others about the very limited, if any, material impact on any flora and fauna species within the national park. Two species that were mentioned were a glider, the yellow-bellied glider, is considered to be present, but the evidence was that it's highly unlikely that transmission line construction would impact that species, which occupies a vast area of contiguous suitable habitat in the surrounding parks. And the southern toadlet, which is known to be present, including in roadside drains, to Mr. Organ's evidence, but that the project would not have any direct impacts on habitats, and proposed mitigation measures are appropriate to address any impacts to that species. And otherwise, in respect of other species, well understood, well known within the park, and no concerns about any impacts on any other species as a consequence of the construction of the transmission line. So when one has regard to the evidence that's been given about ecological type matters, those sorts of natural features of the park, there's really no basis to conclude that would be any material impact or effect at all on those values of the national park as a consequence of the construction of the transmission line. And in respect of recreation, there would be only a very temporary impact during construction of the line, which will be managed in accordance with the traffic management measures that are contemplated through the mitigation measures. And you'll recall the evidence of Ms. Dunstan that Boiler Swamp Road itself is really only a through access point. It has no other function. There's no stopping points along the road. There's no points of interest other than, you'll recall, the half a second of visibility of the boiler on the side of the road as we drove past, and otherwise its use for the Great Southwest Walk with a crossing point over Boiler Swamp Road that will be managed and maintained during the construction period. So when properly considered in respect of recreational values, we also say that there will be no material, if any, impacts on those values of the national park as a consequence of construction. Of course, once construction completes, operationally, there are no impacts at all on those values of the park. So really, I come back to the point that this is a straightforward question, and you have before you very detailed consideration through the evidence of the impacts on these values of the park, and it's readily open to you to conclude that those impacts will be not material, if not minimal. And we say certainly cannot be considered to rise to a substantial effect for purposes of Section 27 of the Act. There's a critical consideration, we say, which is relevant as well. I've left it till last in the written submissions, you'll see it first, which is the fact that the construction will occur along Boiler Swamp Road. Now, that's an existing road that's been in place for many decades, predates the declaration of the national park as a national park. Previously, it was a state forest. And the construction of that road itself, of course, would have had an impact on the natural, ecological and recreational values of the then state park. But there's a significant benefit, an obvious significant benefit to the project choosing to use that alignment, which is that you use already highly disturbed land to put a transmission line, which dramatically minimises any impacts on the national park and its values by reason of that choice. It's an obvious and sensible choice to have made. So we just ask you to, at that higher level, consider when you come to think about with the benefit of the evidence, the question of how the national park will be impacted, that really the impacts have occurred as a consequence of the construction of the road. And there's a great benefit in using that alignment to minimise impacts through the construction of the transmission line. And any impacts consequent directly from that construction, as I've said, are either immaterial or minor. To the extent that there's been some suggestion in questions put on behalf of Parks Victoria to various of the experts about the transmission line options assessment that's documented in Appendix A, Technical Appendix A to the EES. It's not clear to us why or on what basis those questions will be prosecuted through the submissions made for Parks Victoria. But to the extent that they're directed to the question of the appropriateness of a consent under Section 27 and this question of substantially affect, we'd simply say you will not have seen anything in the words of that section that give rise to consideration of different options. So the options assessment in our submission is entirely irrelevant to the question of whether the proposed construction of the transmission line, the chosen option, will substantially affect the park. There's no consideration that arises about alternative options when one has regard to that question, which ultimately, of course, is a question for the Minister. So we will see what is said about that matter next week, and if necessary to do so, we'll reply. But we wanted to be very clear at the outset that the Section 27 question is simply and only directed to the option that is before you, which is along Boiler Swamp Road underground. Been some discussion at various points about an update to Appendix Z, which is the draft consent application. I'll just briefly touch on that, Madam Chair. The first point we'd like to make is, and you'll find this discussion from paragraph 60 of the written submissions, That draft consent application, Appendix Z, was included at the request of Parks Victoria and DECA. It's not an essential component of the ES itself, but it was included at their request. It was, of course, only a draft. Drafts inherently would be expected to be updated. And because of the process we're in and that we're going through currently, the development of the EES, the assessment of the EES, the refinement of various proposals and measures through the course of this hearing and with the benefit of evidence, it's appropriate that that application be updated, and it will be updated before it's lodged with Parks Victoria. But it'll be updated with the benefit of the committee's consideration of the EES and ultimately the Minister's assessment of the EES. So we say that the appropriate time for that update to occur is after those processes have concluded. Because, of course, the decisions ultimately to be made and the advice to be given by the committee might alter various aspects of the project as it relates to the construction of the line within the national park. So it would be premature for us to provide an updated draft of that document during the running of this proceeding. It's appropriately done at a later point in time. At paragraph 62, we've set out for you what we're contemplating that the content of that application would include, which includes background to the project, matters about the description and definition of the public authority that is making the application and would undertake the works, characterisation of the matters relevant to the assessment, including, as I've taken you to orally, the values of the park, the objects of the park, and what is meant by substantially affect a park. More specific and confirmed details of the construction activities, the methodologies that have been under discussion, and ongoing maintenance activities that would be required for the transmission line. And of course, those matters would be informed by the further route investigations and geotechnical investigations, as an example, that will ultimately lead to a resolution about the methodology to be adopted. Evidence as to the anticipated ecological impacts of those activities by reference to this EES process, the committee's assessment and the Minister's assessment. Consideration of other relevant values of the park, and ultimately conclusion about the impacts from those activities and why it is said that they will not have a substantial effect on the park, which of course would be aided by commentary from this committee in its assessment. And finally, any consideration of what permit conditions might be applied or be considered to be applied by Parks Victoria. So that's really all we wanted to say about that application, the consent and the process that would be adopted. I said to you that I would briefly address you on the Forests Act. Now, the relevant section is section 52 of the Forests Act. Bring that up on screen, which provides that the Minister may grant a licence or a permit for a term of not more than 20 years, subject to covenants, terms and conditions that may be prescribed. And this is the form of permission that would be sought in respect of the component of the transmission line that's within the Cobbomini Forest Park. The particular type of permission, other than the licence or permit, if one goes down to the subsection 1C of section 52, you can see a licence or permit granted under this section to enter land set aside in section 51 may be for any one or more of the following purposes, and subsection F is to provide any other facility or service which the Minister considers appropriate. And that's the provisions pursuant to which the permission would be sought. Observe that there's no similar question about substantial effect for purposes of a lease or a permit within on land for land within a forest park, but ultimately the same considerations apply and the same conclusion naturally follows, which is, by reason of the evidence, the matters I've already taken you to, the construction activities would have minimal impact on the Cobomany Forest Park. And we expect that really as night follows day, that where the Minister's satisfied that there's no substantial effect within the national park, then there'd be no reason not to grant the licence or permit pursuant to the Forests Act as well. It's just that the considerations are substantially unconstrained. So that was all we were going to say about those two matters. So thank you, Madam Chair. I'll hand you back to Mr. Chessel.
Thank you. I'll pick up the written submissions at PDF page 20. And we've made some observations about the permissions that are required under the Flora and Fauna Guarantee Act, and the fact that no permission is required under the Wildlife Act at paragraph 66 through 69. At paragraph 70, we address the operation of the Heritage Rivers Act, which is an Act of Parliament that was raised in questions from Mr. Turner. What we want to say about that Act can be summarised succinctly. It is an Act that applies to certain reaches of the Glenelg River, those parts of the river having been declared as a heritage river for the purposes of that Act. The Heritage Rivers Act is in essence directed toward controlling what can occur along declared heritage rivers, and seeking in particular to ensure that the values of heritage rivers are maintained and that they are free from obstructions, maintained in an essentially natural condition. And what the Act does is establish a regime whereby managing authorities are appointed in respect of different rivers. As far as we can ascertain, the relevant managing authority in respect of the relevant parts of the Glenelg River is the Catchment Management Authority. It may also be Parks Victoria. That might be a matter that Mr. Tobin can confirm. Ultimately, however, in our submission, it's of little consequence to the proposal that is before you. And that's because the Act sets out various powers and duties on the part of managing authorities in respect of the relevant areas. And importantly here, the project area does not include any parts of the declared heritage river area. So there is no overlap between the subject land, the project area, and those parts of the Glenelg River that have been declared pursuant to the Heritage Rivers Act. And as a consequence, there will simply be no works or activities undertaken in respect of this project that fall within an area declared under the Heritage Rivers Act. And that being the case, there are no consents required for the project under that Act or any decisions to be made by the relevant authority under that Act. And it follows that the relevant provisions of the Act simply are not engaged as they concern this project. They're the matters that we wanted to address in respect of the applicable legislative framework. What I'd like to do now, Member Kendall, is move to the next part of our submissions that address certain matters that have arisen from the evidence, and use the time up to lunch to begin working through that part of the submission. Before I turn to that material, though, we did want to make some observations about this process, and I suppose start by recognising that you now have a great deal of material before you. Before you even start the hearing process, you have an enormous amount of material before you in the form of the environmental effects statement. Throughout the running of this hearing process, you're furnished with a considerable amount of additional information in the form of evidence, in the form of submissions, in the form of technical notes and other materials filed. And of course, it's your task to review that material in full and reach views in respect of those matters that you're required to consider pursuant to your terms of reference. The reason why I mention that for present purposes is that it's not our intention, or it was not our intention in preparing these written submissions, to try and canvass all of that material. Instead, what we have sought to do in this part of the written submission is address certain matters that have arisen during the giving of evidence throughout the first, 12 days of this hearing. And what I'm proposing to do in oral submission is touch upon some of those matters and expand upon some of those matters, but not rehearse them in full. What we've done in setting out this part of our submission is address certain matters that arise in the order of the evidence as you've heard it. And so the first part of our submission addresses the benefits of the project. And before we turn to the written submission, I'll remind the committee that in our opening submission, we suggested that those benefits can really be considered at two levels of abstraction. The very significant broad-scale benefits associated with the reduction in greenhouse gas emissions as a consequence of the operation of the project and the facilitation of the transition in the energy market. And you recall that in opening our case, we explained in essence that not all wind farm proposals are equal, that there are certain characteristics of this project that give it a competitive advantage in the market, but more importantly for present purposes, mean that it is particularly well placed to deliver the very significant range of public benefits that are associated with projects of this type. You recall that we touched upon the quality of the wind resource at this particular location, the proximity of this project to the transmission network, that is that part of the transmission network that is in place or operational at present with capacity. We talked about the particular benefits associated with the proximity of this site to the single largest consumer of electricity within Victoria. And we pointed to how these particular credentials or these particular attributes of this project are bolstered considerably by its acceptance as part of the capacity investment scheme. Equally, though, we hope the committee will recall that in addition to those broad-scale benefits, we also identified a series of localised benefits that would be realised were the project to proceed. We pointed to the economic benefits of the project, that the direct investment in this particular part of Victoria. We talked about the benefits in respect of the diversification of the employment skill base and outcomes specifically promoted, you recall, under policy. And we identified the relevant commitments made by the client in respect of, amongst other things, the utilisation of local workforce. We also identified, in terms of localised benefits, the series of localised social benefits that arise in respect of the project. That is, the benefits that necessarily accompany the economic benefits of the project. And again, in a process like this, a project that has the capacity to deliver jobs to a community like this is a project that would give rise to very real benefits that need properly be taken into account when one considers social impacts. Of course, we have a social impact assessment that is focused on disbenefits, and particular disbenefits associated with workforce and impacts on amenity and the like. But equally, more holistically, a committee like this cannot, in my submission, properly look past the benefits of jobs delivered by a project like this, not just through construction, but through operation and the diversification in the skill base of the local workforce and regional workforce. And the other benefits that we pointed to of a local nature included the ecological fund that we'll come back to, the very sizable commitment that will be made were the project to be approved, the commitment that will, in our submission, when properly administered, give rise to material, tangible benefits to local and regional ecology, and also the series of community benefits that have been committed to, including pursuant to the CIS program. And you recall that at one point in the hearing, we took you to that information that can be publicly disclosed about the contractual commitments made by my client pursuant to the CIS scheme in respect of community involvement and funding and the like. So in our submission, when you come to consider the benefits of the project, you must properly consider those broad-scale benefits as well as the localised benefits that I've described. And in this part of the submission, we touch upon certain matters concerning those benefits that have arisen or been addressed in evidence. And the first category, or the first topic we address, are those benefits of a broad-scale nature, the reduction in greenhouse gas emissions. And you recall the evidence of Mr. Bolt in that regard. Mr. Bolt, of course, is a highly credentialed leader within Victoria in respect of assessing the benefits of a project of this type, not just in respect of greenhouse gas reductions, but in respect of the particular role and function that a project like this will play in facilitating energy transition. At paragraph 77, we have set out some of the various metrics that are utilised to discuss those benefits. You'll have seen reference in the materials to the energy or electricity generation capacity of 2,000 gigawatt hours being comparable to or equating to the removal of over 600,000 cars from the road, equivalent to the planting of 15.9 million trees. I mean, there are whole different ways you can express the benefits. The key point is that the benefits are very, very substantial, and for the reasons we've already identified pursuant to the Planning Act, need be properly taken into account in the overall balancing exercise called for. For what it's worth, the metric that stands out in my mind as being most significant is the metric we've described at the end of paragraph 77. That is that this project would contribute an amount that is equal to about 5% of the state's electricity generation. 5%, a very substantial amount of generation, displacing or facilitating the type of transition that is so unambiguously called for under state and national or state and Commonwealth legislation. And you recall in opening the imperative placed in legislation to the urgent transition that is required. So this is not a small project, it is a significant project. It will make a significant contribution to the achievement of those types of objectives. So at 78, we say the significance of that benefit cannot be overstated. We rely on Mr. Bolt's evidence about how at a state level, well, I'll make this point very clear. Mr. Bolt indicated that at a state level, without the project, the achievement of the legislated emissions reduction target will become, in Mr. Bolt's words, materially more difficult. Further, it is unlikely, in Mr. Bolt's view, that there would be other projects, either individually or in combination, that would achieve the same level of electricity production and, consequently, emissions reductions with materially fewer impacts. And why is that relevant to your decision? Well, it's relevant to your decision because under the Planning Act, you must consider the achievement of the emissions reductions targets. Those emissions reductions targets cannot be achieved without the facilitation of transition in the electricity market. And the evidence before you is that there are unlikely to be other projects that would achieve the same outcome with materially fewer impacts. What we then do, paragraph 79, is make reference to technical note 25. That's a technical note that we prepared in response to the queries that were raised by Member Kirsch in respect of two things: the nature of the process under the Capacity Investment Scheme tender, and in particular whether there was a public component to that process, and also particular queries about the Victorian Transmission Plan. See if I can gain access to that document. I had meant to save it separately. I wonder whether it's technical note 25. Yeah, there she is. But what I wanted to do is just, in case the document or the issue's been lost in the passage of time, just bring the committee's attention to the executive summary that has been prepared in respect of that document. And if we start first with the capacity investment scheme, what we do at paragraph 2.1 is explain the nature of the program, and that under the program, allocations are given to the participating state and territory jurisdictions, with projects selected following a competitive tender process. The tender process is detailed and requires project proponents, to satisfy a number of eligibility and merits criteria directed toward ensuring that the selected projects will in fact be delivered, will assist to achieve emissions reduction targets, and will provide benefits to the local and First Nations communities. At 2.2, we note that while there is no public participation in the tender selection process, and there is no assessment report made publicly available, which, as I recall it, Member Kirsch, was your particular query, what we do note is that the design of the scheme itself was informed by a public consultation process. And what we say at 2.3 is a point that in our submission should probably be taken into account by the committee. The fact that this project was selected in the first tender round is evidence that the federal government is satisfied that the project can assist in the achievement of the legislated target of an additional 32 gigawatts of electricity capacity by 2030. And recall the size of that and the scale of change needed to achieve that target is very substantial. So this would be a part, a relatively small part, but an important part. And that the project will deliver a number of direct benefits for the local and First Nation communities. Those benefits must be delivered as an outcome of the project by reason of confidential contractual arrangements entered into between the proponent and the federal government. So it is significant. It does demonstrate the bona fides of this project, that it was this project alone that was successful in the first tender round. That is, this is the only Victorian wind farm that was successful in the first round of the tender process. It makes good the propositions that we've identified in respect of the particular attributes of this project that set it apart from other wind farm applications within Victoria. The second issue that we've dealt with in this technical note concerns the Victorian Transmission Plan. And if we just scroll up a little bit to the top of the page, at 2.4, we identify that in accordance with various legislative regimes enacted by the government, relevant guidelines have been prepared and the draft transmission plan has been released for public comment. The first point we make is that it remains a draft, and so the weight it can be attributed is limited as a consequence. But to respond directly to the query that you raised, Member Kirsch, what we identify at 2.5 is that for the purposes of the draft, and specifically the modelling and scenario testing used to identify the proposed renewable energy zones, albeit in draft form, and indeed ultimately the new and upgraded transmission line projects set out in that draft document, the existence and operation of the project has been assumed. That is to say, the draft itself factors in the project for the purposes of identifying the amount of new renewable energy generation that needs to be accounted for in the planning for future transmission line projects in Victoria, and that's been confirmed by VicGrid, the agency responsible for the draft plan. And so the key point, Member Kirsch, is that nothing in this project would compromise the delivery and realisation of the draft plan were it ultimately to be endorsed. Quite to the contrary, that draft plan has been prepared having regard to the potential for this project to be approved. Thank you. So if we return then to the written submissions at paragraph 79, we've made reference to a number of the matters that I've taken you to and that are addressed more comprehensively in that technical note. At paragraph 81, we make a point that we made in opening, which is that notwithstanding these very significant overarching benefits of the project, it's not our position that other matters aren't relevant or that the committee needn't consider other matters carefully. That is, having regard to the draft evaluation objectives and through the lens of the terms of reference. But what we do submit, and as what we hope will be apparent to the committee, having heard all the evidence, that the localised disbenefits that arise from this project are comparatively minimal, that is comparatively small relative to the very substantial benefits that arise and that we've identified. And furthermore, that those localised disbenefits, localised impacts have been minimised through design of the project and through a suite of comprehensive mitigation measures. And to the extent that there are residual disbenefits that are harder to mitigate, in our submission, those disbenefits need to be balanced against the overwhelmingly positive environmental benefit of the project, that is, its contribution to reducing greenhouse gas emissions. And I suppose one can say it's an overwhelmingly positive environmental benefit, but beyond that, it is an overwhelmingly positive economic and social benefit as recognised within the relevant legislation. Now, that might be an appropriate time to pause for lunch. We're tracking reasonably well. We'll cut our cloth accordingly and make sure that we deliver the balance of the submission within the time allocated this afternoon.
Perfect. Thank you, Mr. Chessel. I'll just ask if there are any questions from the committee. No? Thank you. No questions. So we'll break for lunch and we'll see everybody back at 2. Thank you.
Thank you.
Thank you. Welcome back. It's quiet in the hearing room today. We'll get started though. I can see you're with us, Mr. Tobin, so thank you.
Thank you.
Mr. Chisholm.
I'm going to pick up where I left off, which is at PDF page 23 of the written submissions. And before the break, we addressed you on certain benefits of the project, what I described as the broad scale, high level benefits. One of the more localised benefits, though, was the Ecology Fund, and that's what we address the paragraph 82 onwards. The substance of the matters that we address here were touched upon earlier by Ms Guild when she introduced the amendments to the mitigation measures. But what we first observe at paragraph 82 is that in our submission, the benefits to be derived from the implementation of the fund should not be underestimated. They are, in our submission, in the concept and language of the EPBC Act, something that could give rise to a significant impact, a significant positive impact on various species of concern. We note at paragraph 85 that technical note 23 confirms that the fund is not proposed as an offset. That is, and this is quite important, it's conceptually different to an offset. It's not provided to offset a significant effect in respect of the project. It's instead a separate and discrete commitment made by our client with a view to advancing ecological interests in the region, and more particularly ecological interests in respect of those species that are at greatest potential risk as a consequence of the project. It goes, as we've said in the second full sentence, well beyond compliance, and in our submission has transformational potential that was discussed in evidence by Mr Organ, Mr Gibson, Mr Van Oster. And we note in this regard Mr Organ's particular response or commentary in respect of this issue in the response that he prepared to RFI 9. You recall that when giving evidence before the committee, Mr Organ described the fund as a strategic national level conservation initiative. And by that, Mr Organ was identifying that the quantum of the commitment, that is the $30 million investment over the life of the project, is a very substantial commitment to ecological research and recovery. And to give some context to that, we note in footnote 32 that the recovery plan formulated in respect to the southern bentwing bat contemplates the total cost of actions being at just under $4.5 million over 5 years. And so one can readily appreciate the extent to which a commitment of this size and of this nature can be put to good use. At paragraph 86, we note that 2 questions or 2 issues arose in the evidence about the fund. And the first concerned questions asked by DECA concerning the governance of the fund. And you recall that we've addressed that in part in the drafting of the relevant mitigation measure. We fleshed that out to some degree in paragraph 87. And what we note is that our client anticipates that the fund would be administered by an organisation like the Bendigo Bank Community Enterprise Foundation, that being an organisation that manages and implements aspects, or at least manages, the proponent's community benefit funds for other projects. And separately, that it be overseen by an advisory committee comprising an independent chair. That is, that the fund is substantial enough to warrant proper governance procedures being put in place, and that is exactly what the amendment to the relevant mitigation measure is designed to achieve. What we go on to do is identify that the final composition of the committee would need to be determined in due course, but that it could be comprised, subject to relevant parties expressing interest in participating, by a number of representatives, obviously the operator of the facility. Other suitable candidates would be the Traditional Owners Aboriginal Corporation, the Arthur Ryler Institute, the Catchment Management Authority, local environmental groups, and also on a rotating basis, the National Recovery Fund, or relevant organisations implementing relevant funds and projects. So that could include, for example, those concerning the southern bentwing bat and the Australasian bittern. The second issue that arose was the issue concerning how it is that the cash payments required under the BAMP in relation to the southern bentwing bat would be implemented, those being that the penalty payments, if you like, that would be incurred in the event that mortalities are detected, and Ms. Guild identified and addressed how that would be addressed. That is, it would be implemented by the same or pursuant to the same framework, albeit any such payments would be directed exclusively toward the southern bentwing bat. The next part of the written submissions concerns economic benefits. All we really wish to reiterate for present purposes is that Technical Appendix S documents what those benefits are. You haven't heard evidence in respect of those matters, but it doesn't mean that those matters aren't relevant to your consideration. The economic benefits are material and substantial and should in our submission be taken into account. The next part of our submissions then addresses the evidence that you've heard in respect of biodiversity impacts. And we start by making some observations about the evidence that's been called. And before I turn to the written submissions, I'd just like to make some initial observations orally. The first thing I want to say is that this, of course, is an expert panel. You possess your own expertise that you must properly bring to bear. And because of that, you're not bound to accept the evidence that you hear before you. But it is relevant in our submission when you come to bring your independent expertise to bear on the matters that you've been asked to advise on, that you give appropriate weight to the evidence that you've heard. And in circumstances like this, where the weight of evidence points very clearly in one direction, that in our submission should be something that is appropriately factored into your assessment and recommendations. This is a case where the environmental effects statement was informed by detailed assessments completed by Biosis, a reputable firm with very clear expertise in respect of environmental impacts of this type. During the course of the preparation of the materials, it was peer reviewed at various points by various people, and you will see that documented within the technical reports. Furthermore, for the purposes of this process, it was separately peer reviewed by Mr. Organ, and you've had the benefit of not just the Biosis evidence, you've also had the benefit of the views expressed by Mr. Organ. And in our submission, when the committee comes to review and consider that evidence, we ask the committee to carefully review the nature of the written assessments undertaken by Mr. Organ and indeed by Biosis, that is the evidence statements that have been prepared. In our submission, they are comprehensive, they address the relevant statutory frameworks in full, and they provide a very coherent and sound basis upon which to reach views in respect of the impact of the proposal on ecological values. That there is a very clear consensus in the evidence before you is itself a matter of, in our submission, considerable import when the committee comes to consider these matters. So we've touched upon those sentiments, if you like, in paragraphs 91 through 96, and I don't need to address those matters further. The first substantive topic that we address then is native vegetation and threatened flora. And again, before I turn to the written submission in respect of this topic, it occurred to me over lunch when I was reviewing these parts of the submission that to set the scene, if you like, to the matters that we have addressed, there were really two key matters that emerged from the evidence. In our submission, the first of those key matters is that the assessed loss of native vegetation, that is the loss as assessed and recorded within the EES, is relatively low for a project of this type and for a project of this scale. You'll recall that in opening this topic, we identified that a project like the Golden Plains wind farm had a native vegetation removal that was in an order of magnitude greater than that which has been assessed here. So the starting point is that the assessment here documents a relatively low amount of native vegetation removal. And why is that? It's because, in large part, the project is to be situated within a plantation setting. One of the various benefits that comes from co-locating a wind farm within a plantation of the type that is maintained on the subject land. So that's the first key point. The second key point that emerges from the evidence is that the assessed extent of loss is itself highly conservative and almost certainly inflated. And why is that? Because it was based in large part upon assumed losses of native vegetation along Boiler Swamp Road. And those assumptions, or those deemed losses, have been calculated in accordance with the application of the relevant handbook and the application of the Australian standard. But the key point to bear in mind is that neither the handbook nor the Australian standard and those deeming provisions has any regard to the fact that this infrastructure is to be co-located within the road reserve. That is, the calculations, the mechanical application of the deeming provisions takes no account whatsoever to the fact that the corridor within which the infrastructure is to be located has itself already been substantially disturbed. And so, just as in the case of the Section 27 application under the National Parks Act, the co-location of this infrastructure within the road reserve is something that bears very strongly upon the determination of that statutory process. So too here, the fact that we are co-locating this infrastructure within an area that is already cleared of native vegetation is highly relevant, and in our submission establishes beyond any reasonable doubt that the estimates of loss through the mechanical application of these guidelines is sure to be materially overstated, notwithstanding that even taken at its highest, that extent of loss is relatively low. And to make good this point, we note that in the recent correspondence we received from DECA, there was a suggestion that the joint boxes to be situated within the road had to be a certain depth below the level of the road. And the reason for that was that DECA wanted to maintain the ability for deep ripping along the road. So maintenance of the road itself may require at points in time very substantial impact upon that very same corridor, right? And it's just another example of how this condition, that is the condition of the existing road and the extent of impact that has occurred over time and that may occur periodically into the future, is an important contextual element that need be borne in mind when assessing this part of the assessment. And there's been a lot of discussion about detailed design of the alignment within the Boiler Swamp Road Reserve. What we've sought to do in that regard is establish a mitigation measure that creates an appropriate framework to resolve those issues, to avoid unacceptable impacts on native vegetation, and to provide for a revision to the offset calculations to properly record the actual loss that will result as a consequence of this project, which we anticipate, consistent with the evidence, being materially below that prepared for the purposes of the assessment. So with that context in mind, I'd like to now move to the written submissions. And the first point we note at paragraph 98 is that Mr. Galbraith confirmed his view that it was unlikely that construction of the transmission line down the centre of Boiler Swamp Road would impact adjacent trees He made reference to the updated Australian standard in an addendum. That update to the standard creates a different framework within which to assess impact on trees, but ultimately does not give rise to any impact upon the views that he expressed. Paragraph 99, we make reference to questions put to Mr. Gibson and to Mr. Organ in relation to native vegetation and fauna, and that those questions have resulted in refinements and updates to the mitigation measures that we addressed at the commencement of the day. At paragraph 100, we make reference to technical note 38, which provides the reconciliation about the accounting for the extent of native vegetation and the number of trees and so forth. And then at paragraph 101, we address the various questions put to the witnesses in relation to the framework that we propose be established in order to refine detailed design, inform detailed design and refine estimates of loss. That is the route investigation program proposed along Boiler Swamp Road. At subparagraph A, we make a point in writing that Ms Gill touched upon earlier today, which is that in some respects, what had been described as the sampling program, that is the program to testing the extent of root penetration within the road reserve, is perhaps not properly described as a true sampling program. That is, it's not a random series of tests that are proposed along Boiler Swamp Road. Instead, what is proposed is a more targeted regime, that is a regime to test certain parameters rather than sample in a random sense. And you'll see partway through that paragraph, perhaps a third of the way through, we indicate that what is proposed for the project is to test beside the largest trees that are closest to the road. That is the worst case scenario. That is the scenario where trees would be at the greatest risk of impact due to their likely root mass and location. That is to see if any significant roots would be impacted by the proposed construction. If following that regime of testing, there are no significant roots detected, then one can confidently proceed on the basis that there will be no significant roots in respect of the smaller trees. And you recall that there was evidence given by Mr. Gibson to consider stratification and species in designing the investigation program. And in our submission, subject to those matters being given effect as proposed by the revised mitigation measures, the committee can proceed on the basis that the program proposed will be highly robust and is appropriately precautionary. Now, what we go on to do in the submission is document the assessment of impact on native vegetation and threatening flora against the relevant criteria. And at paragraph 102, we note that based on the material before you, the committee should properly conclude that, firstly, the avoidance, minimisation and offset hierarchy established under the guidelines have been applied. Secondly, that the proposed removal of vegetation, even applying the relevant conservative assumptions about deemed loss, is itself acceptable. And thirdly, that offsets can be provided. At 103, we submit that the relevant evidence demonstrates that there is no likelihood of a significant impact to any matter of national environmental significance comprising threatened flora or threatened ecological communities under the EPBC Act. That there will be an unacceptable impact on a Flora and Fauna Guarantee Act listed species, or that any impact on a relevant species beyond negligible or low to minor will result. The final point we make at paragraph 104 concerns the likely extent of, or the nature of offsets that will be required. And we note Mr. Organ's evidence that given the likely extent of native vegetation removal as opposed to the conservative assessment undertaken within the EES, it's likely that only general habitat units rather than species habitat units will be required. why is that significant? It's significant only to the extent that the mitigation measures need properly have a regime whereby the ultimate extent of loss is taken into account in calculating the relevant offsets to be provided, and just in the day 1 and 2 versions. Okay, I'd like to move then to the observations we make about the southern bent wing bat. And again, before I turn to the written submission, I'd like to emphasise the following matters that we did address in opening this topic. And the first matter we wish to emphasise is that this committee has before it the best evidence base to assess impacts on this particular species. That is to say, this committee has more information about the southern bent wing bat and the extent to which a project like this might impact that species than any other panel that has preceded it. And we say that for 2 reasons. Firstly, because the nature and extent of the impact of the project on this species as part of preparing this environmental effects statement goes beyond that completed for any other project. And secondly, because the additional analysis that has been completed in recent times, that is by the ARI and by academic research associated with the ARI, provides supplementary information, but supplementary information that very much confirms the basis of the assessment that was undertaken as part of the environmental effects statement. So the evidence base before this committee in our submission is considerable and considerably greater than has been the case in respect of any previous wind farm. Bearing that in mind, at paragraph 105, we start by making some observations in respect of the evidence given by Mr. Organ. And at paragraph, there we highlight 3 points. The first is a point that I've already touched upon, which is that Mr. Organ described the biosis study as being the most comprehensive survey that he'd seen. Next, Mr. Organ explained that the project is situated within non-preferred habitat for the southern bent wing bat. I think we said we were highlighting 3 things. There might be, in fact, 4 things. And we note that Mr. Organ's observations in that regard were bolstered by the recent publication by the ARI, that publication informed by GPS tracking showing that the movements of bats from the relevant maternity caves favoured natural habitat, and in particular the natural habitat created by the Glenelg River corridor. The third matter identified then by Mr. Organ was that while there are risks to bats flying above 60 metres, few individuals are expected to be within that zone, and that residual impacts be mitigated with the measures proposed. And pausing there, Mr. Organ's view in that regard was not simply informed by the very comprehensive surveys undertaken by Mr. Gibson and by Biosis, but were confirmed, if you like, by the assessment or recent assessment of flight heights that had been informed by the GPS monitoring. And if you just take those 2 pieces of information together, that is the preferred flight patterns of the southern bent wing bat and the heights at which southern bent wing bats have been recorded as flying, one has a compounding sequence of information that demonstrates that the percentage of movements, that is the percentage of movements that are potentially at risk by this proposal, are very, very low. It's not simply the fact that less than 1% of southern bent wing bat flights are below 60 metres. It's the fact that less than 1% of those flights are below 60 metres, coupled with the fact that the majority of movements are within natural environments outside of the plantation setting. You have these pieces of information that stack one upon another that demonstrate here that the potential for impact, that is, the potential for movements to interact with this facility, are exceedingly low. That's the starting proposition. Exceedingly low. And in respect of that exceedingly low proportion of movements that have the potential to interact with the wind farm, what is proposed in addition are a series of adaptive management measures to respond, including, as we've identified at subparagraph D, the implementation of seasonal low wind speed curtailment starting at 4.5 metres per second. And when one has regard to these various pieces of information, these various points of data, in our submission, what one is able to do is complete a proper assessment of risk and to properly conclude that in the case of this project situated where it is within a pine plantation with turbines having a minimum rotor swept height of 60 metres, the prospect of impact is particularly low, and that in that context, the implementation of low wind speed curtailment as a further measure to address the residual risk is an entirely appropriate response to the nature of the risk posed by the project. At 106, we address 4 other matters that were addressed in evidence. The first concerns the study methodology, and in short, we submit that Mr. Gibson's responses to the methodology, questions about methodology, were comprehensive and that they demonstrate that the assessment approach was appropriate. The second issue concerns the capacity to monitor for southern bent-winged bat mortality within a pine plantation setting. And in this regard, we rely upon the material prepared by Symbolics and upon the evidence of Mr. Gibson and Mr. Organ, who both expressed confidence about the appropriateness of the measures contemplated within that advice. The third point we touch upon concerns the low wind speed curtailment. We rely upon the evidence of Mr. Gibson as to why it is appropriate that the initial cut-in speed be implemented at 4.5 metres per second. In our submission, that is a precautionary and appropriate response to the residual risk that exists in respect of that very small proportion of flights that could potentially be affected by the project. And you'll see at subparagraph E that the fourth matter we address concerns the confidence that the committee can place upon the assessment undertaken in respect of this species. What we go on to do is make some observations about some of the recent publications that have been released during the course of this hearing. The first publication we comment upon is the DECA report prepared in respect of the comparison of pre and post construction survey results for birds and bats. And you recall that in that document, document 174, there's a case study in respect of southern bent-winged bat mortality. And you've heard the evidence from Mr. Gibson and Mr. Organ about that report, but we make certain observations about its utility in drawing any conclusions about the impact of this project on that species. The first thing we note at the bottom of page 29 is that both Mr. Gibson and Mr. Organ expressed concerns about the methodology of the study and noted in particular that there is insufficient information about the studies on which the comparison study is based. And indeed, to be fair to DECA, we don't understand DECA to be presenting that case study as being a basis that counts against the nature of the assessment here or the conclusions that are expressed within the EES. But in particular, the reason why one cannot utilise the case study in the way that it was seemingly sought to be utilised by questions put to some of the witnesses by other submitters is that over the page we note that, amongst other things, the assessment was based on only those 3 wind farms where southern bent-winged bat mortalities had been detected, but there'd been no analysis of the extent to which pre-construction studies for the other 7 wind farms where no mortalities had been recorded were consistent with the outcomes of those studies. So it's not a comprehensive study. There's no information about how mortality estimates have been arrived at. That is the statistical extrapolation that seems to have been utilised. Importantly, and indeed critically, there's no details of the relevant turbines of the wind farms, which hadn't been identified. Although, as we understand it, based on the answers that were given in evidence, at least one of the facilities had turbines with a far lower rotor swept height of between 15 and 20 metres. And what we know about the flight height of this species is that at those heights, the potential for interaction is far greater than would be the case if the lowest rotor swept height was at 60 metres. And the other big difference, of course, is the proximity of those other wind farms to relevant caves. So there's just a whole series of reasons why one could not seek to extrapolate from that case study or rely upon that case study in support of a proposition that somehow the analysis recorded within the EES is unreliable or should not be considered persuasive. Now, at paragraph 107, we then make some observations about the document released by the Arthur Ryler Institute, document 154, the foraging flights of the southern bentwing bat. That's the spatial distribution of bat movements. And then the second document is the academic paper published in respect of the flight height patterns derived from the same monitoring program. And the point that we really make at paragraph 108 is that consistent with the evidence of Mr. Organ and Mr. Gibson, these reports comprise in terms of the quality and quantity of empirical information available about this species, both as a result of the work undertaken by BIOSIS and this independent work. And what it shows in our submission are that the findings of the BIOSIS report, I'll start again. What that material does is complement and support the relevant findings contained within the BIOSIS report. I'm happy to leave the balance of this section as read. I'm mindful of the time and the need to move through the submission. You'll see at paragraph 112 and following, we've set out our conclusions in respect of what we say the committee should find in respect of the extent to which the project performs against the relevant assessment criteria as it concerns the southern bentwing bat. I'd like to move now to the Australasian bittern. And what we sought to do in this part of the submission is identify 5 key points that arose or that were confirmed during oral evidence. The first is that both BIOSIS and Mr. Organ had relied on the best available information about the Australasian bittern. And we've made reference here to the Bitterns in Rice project, that is the particular project being undertaken in respect of that species. We sought information from that organisation. We've reported that information that was obtained. It might be that some further information is released in the relatively short term in respect of flight heights. You'll recall that that was contemplated. But what we want to emphasise for present purposes is that the assessment undertaken by BIOSIS and as peer reviewed by Mr. Organ does rely upon the best information that is available publicly. The second point is perhaps the key point that we'd like to emphasise for present purposes, and that is that based on that best evidence, the proper conclusion is that flights of this species across the wind farm are likely to be rare. The bittern, as you will recall, spends most of its time within wetlands, not flying between wetlands. And so you recall that there was a distinction in the evidence between resident movements and migratory movements. And what we observe in the second paragraph of, or the third paragraph of this, the sentence of this paragraph is that the most common flights of this species are the local flights undertaken for foraging. And the very clear consensus in expert view was that those flights are unlikely to be across the wind farm. That's because the bittern is a wetland species and would not have no cause to cross the site having regard to the location of wetlands, and would be likely to take the path of least resistance between wetlands along the coast. If flights across the site were to occur, they would most likely occur during the regional flights, what we have described as the migratory movements. Those movements, of course, are undertaken infrequently by only some of the birds. That is, the evidence is that many of the bittern will not undertake regional or migratory flights at all. And because of that, we're dealing here with only a small subset of movements, that is, a significantly low proportion of all flights. So it's not to say that flights across the site will never occur, but the available evidence suggests that these flights will be rare. And if we pause there, you recall that Mr. Organ sought to distinguish this flight behaviour from the flight behaviour of a species such as a raptor, right, that lives or resides on or around the site of a wind farm, that spends the majority of its time in the air, that circles around and around and around looking for prey on the ground, that's focused on the ground while it's doing so. The risk profile to a species of that type is just so materially different to the risk profile of a species like this, where to the extent that there's any capacity for interaction at all, that capacity is associated with movements that are a very small subset of the broader movements of the relevant species. Furthermore, what the evidence establishes is that the majority of flights are likely to be below the rotor swept height. So even in circumstances where that small proportion of movements does interact with the location of the wind farm, the evidence was that the likely flight at which the birds would be flying is below the rotor swept height. And we address that in subparagraph C. We note that based on the data that is available, it would appear that the higher flights are not expected over flat terrain like that around the project area, that it's likely that even the rarer migratory regional flights will be generally below rotor swept height, although not necessarily exclusively. And so again, when you stack these pieces of information one upon the other, the proper conclusion is that the nature of the risk posed by this project to this species is particularly low. We note at subparagraph D that the setbacks that are proposed from the wetland habitat implemented in respect of the Brolga would clearly have benefits for reducing impacts in respect of this species. Subparagraph E, we make reference to the capacity for emerging technologies such as Identiflight or DHI Muse to be able to provide monitoring data that would confirm whether the bittern do fly across the wind farm, and if so, at what height and at what frequency, and potentially to provide detection and curtailment for the species if trained to do so. That is, if such a response was warranted in accordance with the protocols to be established under the BAMP. At subparagraph F, we note in relation to questions about the efficacy of those types of technologies to operate in respect of nocturnal movements, that Identiflight has good low light capacity at present. That's a matter addressed within the relevant technical note. Also within the same note that Identiflight and that type of technology are developing nocturnal capacities. And furthermore, that the radar-based technology, that is the DHI Muse technology, already has nocturnal capacity. But the final point that we make in respect of the bittern is that if offsets are ultimately required, because the committee concludes, or the relevant decision maker, I should say, concludes that the project would give rise to a significant impact on the bittern, then the very clear evidence before you is that there are likely to be plenty of suitable offset sites available, having regard to the success of wetland restoration projects and the nature of much of the farmland having been drained in and around the site. And you recall that the committee has material before it that comments upon particular sites and their potential suitability. So where does that leave us in respect of the bittern? In our submission, what one sees when you have regard to the conservation advice and the National Recovery Plan prepared in respect of the species is a particular emphasis on loss of wetland habitat and habitat degradation. And of course, this project will not give rise to any loss of any such habitat or any degradation to any such habitat. The key consideration here is the potential for collision impacts. And you recall that it was in respect of that potential impact that there was a difference between the evidence given by Mr. Organ and Mr. Van Oster. We've addressed our position in respect of that difference at paragraph 124. And in that regard, my client accepts that the potential impacts on the bittern fall close to the line that divides significant versus non-significant impact. And the questions from DECA to the witnesses, I thought, helpfully clarified the nature of the difference between their respective views, that is, the views of Mr. Organ and Mr. Van Oster. And in essence, that difference came down to differences in views about the relevant population size used and the application of the precautionary principle. I think that Mr. Van Oster's evidence was that in light of the recent population projections, the extent of modelled impact would be marginally below 1%, which, if one were to take a strict view, would have him on the side of the non-significant impact line. That's, of course, the view that Mr. Organ expressed. But that Mr. Van Oster's view, consistent with that expressed in the EES, is that a more conservative approach would be to assume that there was a potential for impact to arise that would warrant or would meet the significant impact threshold. What's important to note in our submission, though, is that there was no difference between the witnesses in relation to the assessment of the likelihood of collision or in respect of flight behaviour. It was simply a difference born from how one approaches the mechanical operation of the significant impact guidelines that concern this species. At 125, we make the submission that Mr. Organ's approach is preferable. That is, that based on the information before you, that is the best information that is available, the proper finding is one of no significant impact, and that the precautionary principle here does not dictate a finding of significant impact. You recall that in opening our submissions in respect of biodiversity generally, we were at pains to point out that the precautionary principle doesn't mean that one should be cautious. The precautionary principle has work to do in circumstances where there is uncertainty in respect of impact, and that uncertainty should not be used to warrant not implementing certain measures to mitigate impacts. So in our submission, Mr. Organ's approach is to be preferred. If the committee agrees with that, then the consequence would be that no offset would be required. But if the committee doesn't agree with that assessment and instead favours the evidence of Mr. Van Oster, then the consequence is that an offset would be required. And as we've already noted, the evidence before you was that there should be no concern that an offset of a relevant type would be available and capable of being implemented. The key point, though, and a point that I sought to emphasise earlier in the day, is that in either case, in here, the proponent has committed to pre-commissioning monitoring of the bittern to enable better understanding of that species' flight behaviour, particularly as it's relevant to this project, and to investigating the use of technology for detection and curtailment during operations. And given the likely utility of that technology as set out in the relevant technical note, in our submission, the committee can be satisfied that residual impacts will be minimised. And indeed, I think it was Member Wilkinson made an observation during the running of the hearing about the operation of the precautionary principle and how it might manifest in respect of a project like this. And in our submission, in light of the nature of the evidence that you have before you concerning the extent of risk to these various species, here, this type of monitoring program, that is the type of program established under the BAMP, to be given effect through adaptive management principles is a true and proper application of the precautionary principle, having regard to the nature of the residual risk posed by the project before you. Now, the next topic we address concerns the Brolga, and the opening remarks I'll make about this species, before I turn to some of the written comments, is that to some extent in our submission there was a disproportionate focus on this species during cross-examination. And I say disproportionate not because the impact on this species is not important. Of course it's important, and it's a matter that need be carefully considered. But I think it's a function of the fact that this is one species wherein we have a established framework that allows for a consideration of effect, that framework for this project being that established under the interim guidelines. And it's perhaps because we have the interim guidelines and the framework that it creates that so much of the questioning was focused upon the efficacy of that framework, whether particular steps had been taken in accordance with that framework, or whether further measures were required pursuant to that framework. But when one steps back and considers the nature of the assessment that was undertaken, in my submission, the committee should readily accept that here a very comprehensive assessment was completed, and that comprehensive assessment gives effect to and implements very carefully and directly the measures called up under the guidelines to inform an assessment of this type. Now, at paragraph 129, we note that Mr. Van Oster explained in detail the nature of the impact assessment that was undertaken. Mr. Van Oster expressed a high level of confidence in the assessment in terms of ensuring a proper understanding of local habitat and behaviour. And as we note midway through paragraph 129, it's difficult to see how, after the detailed assessment set out in the relevant technical appendix, that there is any realistic chance or potential of impacts to Brolga breeding habitat having been missed. The committee might recall on the first day of the hearing that there was a suggestion that there was a flocking site that had been disregarded, that is the flocking site within Oxbow Lake. And you heard the evidence from the witnesses to how that data had been taken into account. And there's obviously no suggestion, it seems, in questions put to the witnesses that that approach had been incorrect, or that somehow important information had been overlooked. Similarly, there were a whole series of questions about the adequacy of the consultation program that had been undertaken. But as Mr. Van Oster explained, a very detailed approach was taken to identifying relevant habitat, and at no point in time in the cross-examination of the witnesses was it suggested that somehow a particular wetland had been overlooked or a particular breeding site had been overlooked. Instead, what became readily apparent from the evidence was the extent to which the analysis was comprehensive and the extent to which it had identified all relevant habitat and prepared appropriate responses in light of the potential impacts of the project. We note that this aspect of the review was peer reviewed on multiple occasions. It was peer reviewed by Mr. Organ. But at paragraph 130, we make reference to the peer review of Mr. Loyne, and relevantly, that peer review noted the following in respect of the adequacy of the analysis. At paragraph 130, we note that Mr. Loyne stated that the report on Brolgas provides a thorough picture of the local population and likely effects of the proposed wind farm operation. Data were collected both from field observations and consultation with local observers, and I believe a comprehensive picture has been obtained of the main habitats used in this area and the likely flight paths. The report is impressive in its detail, and in our submission, the committee should reach the same conclusion. At 131, we make observation about aspects of Mr. Van Oster's evidence. Firstly, the approach to buffering wetlands located within buffers around breeding wetlands. and to buffering movement corridors, allows for Brolga to make use of resources adjacent to breeding wetlands and potentially important to successful breeding. As Mr Van Oster explained, it's a conservative approach, indeed a more conservative approach than adopted for any other project of which Mr Van Oster was aware. So I think it's important to understand that the approach adopted here is different to the approach adopted in respect of other wind farms in Victoria, different in important respects that distinguish it as being more conservative. Secondly, that the buffers for the project were informed by directly relevant, peer-reviewed, published scientific work by Veltheim et al. And of course, there was a whole series of questions seeking to challenge the validity of that research. But in our submission, it is entirely appropriate that analysis of this type be informed by that type of analysis, that is scientific, peer-reviewed, published analysis. Thirdly, we note that the collision risk modelling was based on informed and highly conservative assumptions. And finally, we note that the interim guidelines are specifically stated to address cumulative risk as well as individual project risk. That is, a response to the interim guidelines is a response both to project-specific risk and cumulative risk. Before I go on to make observation about Mr Organ's evidence in this regard, I do think it's appropriate to observe that the new handbook, that is the handbook recently released by the department in respect of the assessment of the environmental effects of wind energy projects of this type, specifies or updates the interim guidelines as they concern the specification of Brolga buffers. And we accept that this project is not one that is to be assessed pursuant to that handbook. But we do note that the new handbook specifies a regime of identifying buffers that is identical to that which is has been advanced in respect of this project, albeit pursuant to the interim guidelines. And to make good that point, I'll just identify the relevant passages from that document. Difficulty with, for some reason, my documents haven't updated on my computer. If we could just find the updated handbook and share it on the screen, and go to the appendix that concerns this issue. I just control it. That's okay. Thank you. What one sees in this document, which is the updated handbook, is that a particular approach is adopted regarding the specification of buffers. Firstly, at 4.1, there are measures proposed to avoid impacts on flocking areas, and the same definition is utilised. Here, there are no flocking areas within relevant proximity of the project. Then at 4.2, there are measures proposed to minimise impacts, and those measures require the application of breeding wetland buffers to be applied to all wetlands that are Brolga breeding wetlands. And when one tracks through the relevant document, one sees specification as to how breeding wetland buffers are to be formulated. And one sees a 900-metre buffer as being required, that is a 600-metre foraging buffer, plus a 300-metre disturbance buffer. as being required around a brolga breeding habitat. And when one reads on, one sees that those buffers need be applied not just in respect of brolga breeding wetlands, but other wetlands within 2 kilometres of the home range of those species. So you recall that that is in fact precisely the approach that Mr. Van Oster adopted in formulating the buffers in respect of the breeding wetlands. And why I bring that to your attention is that even if the committee was to accept the submissions of the objectors in full, which in our submission it should not for the various reasons given in evidence, the consequence would be a requirement that a further assessment be undertaken. That further assessment would be undertaken pursuant to the updated handbook, which unambiguously specifies that the very same approach that is adopted here be adopted for the purposes of specifying buffers. And I suppose really what I'm saying is that the fact that the new guidelines have been, or the new handbook have been formulated in that way, provides very real support and endorsement of the science-based approach that has informed the identification of buffers in this case. That is, it is a very strong endorsement of the validity of the approach that Mr. Van Oster adopted and BIOS adopted in specifying buffers for this project. Now, we make a number of observations at paragraph 133 in response to matters raised by various submitters. It seemed to us that a number of the questions sought to attack the approach that's required by the interim guidelines in respect of the assessment, avoidance and minimisation of compensation. To the extent that that was the case, we say that those questions were misguided because the interim guidelines are properly adopted to inform an assessment of this type. Over the page at subparagraph B, we note that many of the questions put by submitters proceeded on the basis that the work undertaken by Veltheim et al. Was incorrect. If not, frankly, there seem to be suggestions of improper conduct on the behalf of the authors of that work. In our submission, those allegations are entirely baseless. The work was peer-reviewed. It's been published in a reputable scientific journal. It's now informed quite clearly the updated handbook, and it does, in our submission, constitute current scientific knowledge and should appropriately inform an assessment of this type. There were a number of questions put concerning the adequacy of the assessment, but no suggestion that a specific breeding or flocking habitat had been missed, and we make that observation notwithstanding the earlier assertion on the first day of the hearing that somehow there was a flocking site in Oxbow Lake that had been overlooked. And finally, in our submission, the submitters' propositions to the effect that operating wind farms within Victoria would give rise to displacement should be rejected. And in that regard, we rely upon the detailed work that Mr. Organ has done in comparing the pre and post completion monitoring reports that were tabled by Mr. Cumming. And we make the further observation that the interim guidelines themselves explicitly contemplate that the application of a 300-metre buffer in addition to the buffer to be provided around breeding sites is itself a measure directed toward disturbance effects. And as such, to the extent that such effects exist, this project has responded in accordance with the terms of the guidelines. Now, at paragraph 134, we note that during oral evidence, there was discussion about the potential for an additional offset to be required if there was to be disturbance of breeding near the substation. In our submission, Mr. Organ's response in that regard was correct. That is that the potential impacts and offsets are to be assessed up front, that is, as part of the relevant approvals. And the regime does not contemplate that one go back and require a greater setback or a greater offset subsequently. And on a more practical level, it's emphasised that the likelihood of disturbing breeding is reduced given the relevant wetlands are not confirmed breeding habitat. And you recall that during evidence, Mr Van Oster and Mr Organ were taken to the program of works contemplated in respect of the substation, and both expressed confidence that the relevant staging could be accommodated in a way that would be unlikely to give effect to those types of effects in any event. So consistent with all of the evidence in our submission, the committee should properly reach a conclusion that in accordance with the interim guidelines and subject to the implementation of the various mitigation measures, this is a project that would achieve a net zero impact in respect of this particular species. In the remainder of this part of the submission, we deal with the balance of, or at least some of the species that were the subject of evidence. Again, I'm mindful to move through these submissions efficiently, and I suppose for present purposes, what we have sought to do is emphasise that in each case, that is in the case of each of these species, it's important to have regard to the particular attributes of the species that bear most directly upon the potential for the project to result in impact. In the case of the southeastern red-tailed black cockatoo, we observe that the relevant factors that support the conclusion of low impact, that is not a significant impact, is firstly the fact that the cockatoo's preferred habitat is located to the north of the project and that there is no suitable habitat to the south of the project area. While there are a limited number of observations of that species to the south of the site, Mr Organ expressed doubt about the accuracy of at least some of those records. But more fundamentally, those records are few and far between, and in accordance with the evidence, there's simply no reason why that species would regularly traverse the site to access habitat to the south. Furthermore, we make the observation at 139 that the best evidence in respect of the cockatoo is that they're likely to fly below rotor-swept height, except in exceptional circumstances, that is, where they're being chased by a bird of prey. And so again, when one puts those two pieces of information together, the proper conclusion in our submission is that the prospect of impact is low and indeed below the relevant threshold. We next address the orange-bellied parrot. In respect of this species, we note that at 142, consistent with the evidence of Mr Gibson and Mr Organ, there are few records of the parrot within and around the project area. As Mr Organ put it, one would expect the odd individual some years apart. The situation is materially different from that of other wind energy facilities assessed in recent times. The committee might be aware of the Robbins Island wind farm, the Tasmanian project, that is situated directly within the migratory flight path of the orange-bellied parrot. Here, while there are some parrots recorded to the south of the site, their presence is sporadic at best. Secondly, what is understood about this species is that their presence is restricted to coastal areas, that the project itself is not suitable habitat. And thirdly, having regard to the best available information about flight height, it would appear that the majority of movements are below 60 metres. We address the blue-winged parrot, pointing to a number of similar attributes of that species next. At paragraph 148, given the data that is on hand in respect of that species, it was possible to complete a collision risk monitoring process, and that process or that study provides evidence to support a proposition that it's unlikely to comprise a significant impact on the population size of that species. White-throated needletail is in a different category to some extent. It was able to be assessed utilising collision risk monitoring methodologies, and that study supported a conclusion that the impact of this facility would not represent a significant impact on the national population of that species. I think the key point, or a key point at least, in respect of this species is that given its broad distribution across Victoria, the risk posed by this project should be considered comparable to the risk posed by any other wind farm project located within Victoria and certainly within southwest Victoria. That is, any other project comprising the same number of turbines at the same height. That is, there is nothing about this particular location that poses a greater risk to this species than would be the case elsewhere within Victoria. Then we address the grey-headed flying fox and finally other flora and fauna. And I suppose, members of the committee, once one completes that exercise, in our submission, the proper conclusion is that whilst this site is located in an area that bisects two areas of relatively high ecological value, that is Discovery Bay to the south and Glenelg National Park to the north and the Cobbobinnie Park to the east. What a detailed assessment reveals on a species by species basis is that the particular design, the particular mitigation measures proposed here are measures that will successfully ensure that this is a project that will not give rise to material or unacceptable impacts on any of the species of concern. And when one undertakes that detailed assessment, as Biosis has documented within the EES and as Mr. Organ has undertaken in his peer review, in our submission, the proper conclusion is one that the project should be considered acceptable having regard to its impacts on biodiversity. And that's really what we say at paragraph 162 of our submission. In our submission, the key conclusions that should be drawn from the analysis is that with the implementation of the proposed mitigation measures, there will be no significant or unacceptable impact in relation to any species of concern. And secondly, that if the committee finds that there may or will be a significant impact in relation to any particular species, and perhaps the Australasian bittern being the one that is closest to meeting the threshold, any impact can adequately be compensated for with an offset, and furthermore, that it's likely that a suitable offset can be found. Okay. The next section concerns the Ramsar site, hydrology, groundwater dependent ecosystems. In our submission, this really is or should be an uncontroversial aspect of this assessment. Simply put, there is very little, if any, prospect of this proposal having any effect on the hydrological processes of the Ramsar site. We rely on the evidence of Mr. Hughes and Dr. Fawcett in that regard. It's here at paragraph 165 that we address the matter that I noted in opening, which is that there is the updated draft of the Ramsar site management plan that has been released. It's a draft document. It has little weight. Even if it did have weight, its substance would be of no consequence to the assessment before you. That is, it does not change substantively the matters that are identified as being significant in respect of the Ramsar site, or at least those that would be impacted by or potentially impacted by this project. Unless there are any questions, I'm going to move now to the balance of the topics. I'll note that perhaps the convenient thing to do would be to address social impacts, and then if you wanted to take a break, we could break before addressing landscape impacts.
That sounds like a good plan. Thank you.
Thank you. For the social impacts, essentially we rely upon the evidence of Mr. Weston that was heard before you, and we've made consequential changes to the mitigation measures to give effect to Mr. Weston's recommendations. The one matter we have addressed in submissions concerns the questions that were asked on behalf of Parks Victoria about consultation with tourists, including those who had completed the Great Southwest Walk. And what we're at pains to confirm is that, notwithstanding the fact that consultation was undertaken during the period where COVID lockdowns were in force. There was direct engagement with relevant stakeholders. When one reviews Technical Appendix R to the EES, one sees a record of consultation with community members, including survey respondents who did not live in the area but visited for recreation, that is, tourists. There were interviews with visitors to Nelson conducted outside the Nelson Visitor Centre. And you recall that someone had been placed there for a number of days, partly with the intention of interviewing people who had completed the Great South West Walk to understand their views in respect of the project. And there was direct consultation with local tourism providers who expressed neutrality in respect of the proposal, and we've included the relevant references at footnote 77. More generally, we note that the potential impacts of the project on tourism is a focus of Technical Report R, and that any suggestion that it didn't take into account the views of tourists should be rejected. I suppose the other point that we wanted to emphasise here, which is a point that we emphasise or that's relevant to a number of different disciplines, is that when one comes to consider the particular impacts of this project on tourism and on the extent to which it would impact upon one's experience of utilising the Great South West Walk and the national parks more generally, is that there will undoubtedly be a range of views on the part of people who experience or utilise those facilities. There will be a group of users, we would suggest the largest group, who support the project conditional on the renewable energy benefits that it will deliver. There will be a smaller group that does not mind the project at all. And there will be a small minority that oppose the project and that resent the visual or other impacts that it will deliver. And so when one comes to consider impact in this context, often there are qualitative descriptions of its effects. So is it high, medium or low? And certainly in the context of landscape and visual impacts, that type of language is used. It is a high impact from certain perspectives, it is a moderate impact from others. But simply because it is a high impact does not necessarily mean it is a negative impact. That is, how one perceives the project and its attributes will inform subjectively how one responds. And in our submission, that's an important matter to bear in mind, particularly in the context of the next topic that we'll come to address, being landscape and visual impacts. Now, Mr. Wright will address this topic. Would you like to do that after the break, or would you like to keep moving ahead for present purposes?
If Mr. Wright's in a position to do it, I think I'm happy to continue. Just check. Yes. Happy to continue. Yeah, we're happy to continue. Thank you.
Well, thank you, Madam Chair. Thank you, Mr. Chessel. Members of the committee, there's 6 matters. I should put it this way. We've provided you some detailed written submissions in the written submissions about this topic in particular. There's 6 matters in those topics that I'd like to take you to. The first of those is something that Mr. Chessel has eloquently addressed this morning, which is, what is the question for the committee to consider when it comes to consider the visual impacts of the project? And I'm not going to spend any more detail other than to just reiterate what Mr. Chessel effectively said this morning, is that the task is, the integrated decision-making task is one of weighing all of the benefits against all of the detriments of the project. It's not appropriate to consider or assess individual impacts in isolation and identify whether those individual impacts are considered to be acceptable or unacceptable. The question is about acceptability of the project. And it's at that level of abstraction that one has to consider the impacts, each of the sub-impacts and each of the sub-benefits of the project. So it's important that the consideration starts at the correct level of abstraction, which is something that Mr. Chessel's described to you this morning. The second matter just really addresses that final point that Mr. Chessel's just made, and that's to say that visual and landscape impacts is a highly subjective matter, highly subjective. And it would be a false premise to start from an assumption that landscape and visual impacts are always negative. That's just not the case. They're inherently subjective. The impacts, even if they are high, even if they're moderate high, will be negative to a proportion of the population that is in a position to view the change in the landscape, and another proportion of the population, and we would say a greater proportion overall, will consider those impacts to either be of neutral effect or of positive effect. So it's also important, similar to the first topic, to start from the correct premise, which is that the impacts are not always to be considered negative, and only a proportion of the population will consider them to be so. But most relevantly for the task that's before the committee and ultimately the minister here, is that the assessment of impacts on landscape and visual matters need to be assessed objectively against what it is that the scheme seeks, the planning scheme seeks for the land in question, and to set aside subjective considerations to the extent that's possible to do so. So the task is to objectively consider those impacts through the lens of what the planning scheme seeks for the land in question. So that's the third topic I'd like to address you on, which is what does the scheme say or seek for the land in question? You've had the benefit of some detailed submissions in various parts of our presentation, through submissions and evidence, I should say, about, in particular, the SLO, and we've had some discussions about the Coastal Spaces Landscape Assessment Study, and I'll touch on those briefly. What we say, though, primarily is, of course, landscape and visual impact matters are clearly a relevant consideration for the committee by reference to the project, and it's made relevant by the farming zone, by Clause 65, by general policy, and for specific land by the application of the SLO1. But in respect of the totality of the project area, it's only the SLO1 area, that small component of the project area, that is given an elevated level of significance in a landscape sense by the planning scheme through the application of the SLO1. And that's occurred through a series of deliberate choices that have been made by the planning authorities over time to only apply the SLO1 to that particular area and some other areas further to the east, but not to the balance of the Discovery Bay Coastal Park, and consequently not to the bulk of the project area. Now, we can't look behind the curtain, if you like, in respect of those decision-making processes. It's appropriate to apply the scheme as it is, and to apply the SLO1 with that elevated level of significance to the landscape only to that area. But the same is not true of the balance of the project area, including locations at Lake Mombiong and at Swan Lake. We can't elevate the significance of those locations in circumstances where decisions have been made to not apply an SLO to those locations. Turning briefly to the Coastal Spaces Landscape Assessment Study, already made submissions to you about the way in which that document ought to be treated by the committee. We recognise it's referenced in various policy documents in the scheme, and it's referenced in the decision guidelines in the SLO1. But as has been addressed to you by Mr. Chessel already, and also through the evidence of Mr. Glossop, that document is a background document to the scheme, and the contemporary way in which those documents are to be treated is to inform how and why provisions have been placed into the scheme, but to not go further than that. And consequently, for purposes of your assessment of the project, that document has only little relevance, and really no weight can be placed on the content of that document other than to inform how and why the SLO1 was applied. I'm not going to take you back to our responses to the decision guidelines in the SLO head clause or the landscape character objectives and decision guidelines in the schedule. You've had some detailed evidence on those matters and submissions on those matters already. But what we'd like to say about the SLO1 location and the 12 turbines that are within that area is just to observe again that the location of that part of the project area does not display any of the characteristics of the natural and landscape elements that are identified in the SLO1 in clause 1. It's removed spatially from the areas that are identified, which is primarily the Glenelg River mouth and that part of the estuary, the coastal strip and the dunes and the vegetation associated with the dunes. That's the focus of the SLO1 and the 12 turbines that are in the project area, but nonetheless to which the SLO1 apply, as has been the evidence of Mr. Hark, don't interrupt or materially impact any view lines to the protected attributes within the SLO1. And we can say with some confidence and clarity that the project itself doesn't offend the landscape character objectives in the SLO1, and certainly not to the point of, we would say in our submission, unacceptability or the need to remove any turbines from within that area. The next matter I'd like to address you on is the residential impacts from the project. And as we've observed in a number of times and in respect of a number of subject matter areas, this is one of the issues where the locational attributes of the project perform very strongly. That is to say, there are very few impacted dwellings around the project area in a landscape and visual sense. That the evidence is that within the assessed 10-kilometre buffer around or extent around the project area, there are only 44 non-involved dwellings that fall to be considered. And of those 44, there's only 6 where the impacts have been considered to be moderate high to high and consequently warrant an offer of landscaping to ameliorate those impacts. It's only 6 dwellings. We observe that there's also been no challenge to the assessment in the LCVIA, the methodology that's been used in that assessment, or fundamentally the conclusions in that document or Mr. Hark's conclusions in respect of residential viewpoint impacts. There's also been no challenge to where the line is to be drawn in terms of whether the impacts are moderate, high, or whether those that is the extent of impact that warrants off-site mitigation. So none of those matters have been subject to any material challenge through the course of this process so far. What I would like to say about that in totality is that it's in fact quite remarkable that a wind energy facility of this scale, which would be on its completion the second largest wind energy facility in the state, can have so little by way of residential impact. And that's a testament to the choice that's been made to place the facility within a plantation that has so few neighbours to it. I'd like to give you a point of comparison in respect of these impacts. And a place that the committee can go to understand that point of comparison is to document 352, which is the panel report for the Dalburn Wind Farm. And you can see on screen there the section that deals with residential dwellings. And it says there, similar to what is the case for the LCVIA for this project, is that the LVIA there assumed landscape sensitivity from individual residential properties will always be high because homes are highly sensitive locations for residents. And goes on to say the LVIA found 1,567 dwellings within 6 kilometres of a proposed turbine. I'll pause there and remind you, in terms of non-involved dwellings, there are 44 within 10 kilometres of the project. And then the report then says it identified 317 dwellings in the high visual impact zone within 3 kilometres of a turbine, where a blade tip height of 250 metres would always be visible as shown in figure 10. Now, I'm not suggesting that all 317 of those were considered in that assessment to be subject to high impacts that warranted landscape mitigation. So it's not an assessment of 317 there versus 6 here, but it's an orders of magnitude higher in terms of the numbers of dwellings within the viewshed location and the numbers that were considered to be in a high visual impact zone location for Dalburn as compared to this project. In the future, I'll come to the conclusions that were drawn by that panel for a different purpose. But over the page, on PDF page 50, you'll find a figure that shows the Dalburn project outline, and you can see the number of dwellings in proximity to that project area. Needless to say, this project was approved. To just make the point visually, this is the Appendix L, LCVIA, and you can see the project area that is familiar to you. This is PDF page 107, and if you can see my cursor, this is the 10-kilometre viewshed line that was the subject of assessment, all dwellings within that line, and the orange houses are those houses that have been assessed around the project area. Now there's 50 in that image because 5 of those were involved and one was a shed. So again, we're only dealing with 44 dwellings within the viewshed, and only 6 of those have been considered to warrant off-site landscape amelioration being offered. It really is quite a remarkable observation to make about the appropriateness of the choice of location here. We'd say to that end that it can be considered by this committee to be in fact a major benefit of this project, and I mean this by reference or comparison to other potential projects, and specifically in context of what the scheme seeks by way of consideration of emissions reductions targets and consequent need for projects like this, that the residential impacts of this project are so low. Now, the fifth matter to address is the public views.
Mr. Wright, I'm just looking at the time. I know we have run into the break a little. We might break now for come back at 20 to 4.
Certainly.
Keep going. Thank you. So we'll just break shortly. Thank you. I've got in the grant here, you can help with the vibrate. I'm just Thank you. And I know I'm just going to do a quick check. I know, Mr. Chessel, you were saying earlier that you would cut your cloth to the length of the day, and I just wanted to check, do you think that we're still on track for finishing today?
Yes, I do.
Okay, lovely.
Yes.
Great. Let you continue.
Thank you, Madam Chair. Before I move to public viewpoints, I should just clarify something. Residential impacts. The 44 individual dwellings were assessed, but that doesn't include the consolidated consideration of the Nelson dwellings, which are to an extent also within the 10 kilometres. But in respect of those dwellings, other than the Wade Street properties that we visited on the site visit, they were considered to be negligible to low impact. Now, in relation to public viewpoint locations, there's really, in our submission, 9 locations that fall to be considered. And those locations are the estuary mouth and the foreshore, Nelson itself, views from Nelson, views from along reaches of the Glenelg River, views when travelling along Portland Nelson Road, views from the opportunistic lookout at Hedditch Hill, Jones Lookout, Swan Lake, views along the coastal extent of the Great Southwest Walk, and finally Lake Monbiong. There haven't been, in our submission, any other viewpoint locations identified through the course of this proceeding that warrant consideration. Otherwise, hasn't been identified any viewpoints that need to be considered that weren't considered through the LCVAA and then by Mr. Hark. So we think the committee can conclude that the assessment in relation to the public viewpoint locations was thorough and robust, and we observed that the proponent, through and with Mr. Hark's assistance, has sought to be responsive to requests from submitters for consideration of additional viewpoints, and there have been further assessments where Mr. Hark has considered it was necessary to do so. But we observed that none of those additional assessments have changed any of the overall conclusions in respect of impacts on those public viewpoint locations. We suggest, as we have in the written submissions, that out of those 9 public locations, there's really only one that warrants more specific consideration, which is Lake Monbiong. And we don't, in doing or making that specific identification, seek to play down the other locations. We think they have been the subject of detailed and thorough assessment through this process, but we suggest that it's perhaps more clear that those locations are, impacts on those locations are more comparatively minor and in context more clearly acceptable. But Lake Monbiong, we do say on initial consideration warrants more consideration, and perhaps that's because of the immediacy of the impact and its proximity within the central part of the turbine field, and the fact that there's a number of different locations in that area where turbines would be visible from. But as Mr. Chessel indicated this morning, it's appropriate to contextualise, if you like, the merits of the impacts at that location. And the matters that we've identified in the written submissions are these. I've already addressed you on how the impacts are to be considered in the aggregate, not for any particular location. That's the first matter. The second matter is one I've already taken you to, which is that impacts at that location will not be considered considered negative by all viewers. Some will perceive them as neutral or positive. The third aspect, which is an important one, is that because the turbine field, turbines in that location or from that location will be visible within the pine plantation, it's important to understand what the pine plantation is in a visual and landscape character sense. It's, in our submission, appropriate to consider it as a highly modified industrialised plantation landscape. It's also a landscape that is subject to periodic and dramatic change as trees are harvested. When that harvesting occurs, the landscape changes to one of a treed landscape to one of bare earth until such time as the trees regrow, which takes a number of years. The consequence of that landscape character, in all views, where the turbines are visible in context of the plantation from Lake Mombiong locations is that the reasonable visual amenity expectations of the viewers is necessarily lower because of the fact that the landscape will always be subject to change while the plantation is there. We think that's an important matter that of itself ameliorates any consideration of impacts on viewers from that location. The next matter is the number of viewers and the duration of views. And perhaps the first point of distinction that's relevant to draw is that this is a campground location, as distinct from a residential viewpoint location. And so inherently, the duration and number of views and viewers is much lower. The viewers who come through the campground will always be transient. That is particularly the case when one considers views from the inland track, not a residential location in the sense of you're not putting up a tent on the inland track. It's only for walkers as they come to and fro. To a similar but lesser extent, the same is true from views from the Mombiong Lake jetty, where people are only there for periods of time. It's also true, although the views would be longer in duration than those, for the campground itself, where people are there for only short periods of time comparatively. We've provided to you in the document numbers from 138 to 141 a range of campground utility booking information that we've obtained from Parks Victoria and that we've sought to synthesise in the first of those documents. And what it suggested to us on review of that documentation and the bookings was that the periods of use for this campground are particularly concentrated around Christmas, the Easter period, and around the Melbourne Cup long weekend, and when visitation spikes. But otherwise, for the vast majority of the year, visitation for those or usage of those campgrounds is very low. We've also said in paragraph 188 that even during those busier periods, the number of viewers who would be impacted by visibility of turbines is necessarily constrained by the comparatively small number of campsites that are available. So it's a factor we say that further ameliorates the overall consideration of impacts at that location. The fifth consideration in our submission is a concept where we address at paragraph 189, which is that landscape scale changes, including by the introduction of infrastructure like wind turbines, may initially be quite dramatic. It's really the before and the after, immediate before and after, but they tend to fade over time in perception to become another part of the landscape. And we say that by reference to experiences with other wind farms around the state that have been inserted into the landscape and then become part of that landscape, and other types of infrastructure that we're all familiar with, which includes power lines and mobile phone, telephone infrastructure, for example, which when we were standing at the Wade Street location, Member Joyner identified the location of one mobile phone telephone pole in that viewscape. So in our submission, it's the case that whilst there may initially be concern about the change from the insertion of infrastructure like this into the landscape, that over time, that levels of concern about these matters do tend to fade. Now, that's not going to be the case for all viewers, but we suggest that it will be the case for the majority of people, including it'll be the case for those who haven't had experiences of this location absent the infrastructure. And so consequently, we don't think it's the case, or can be concluded, that the introduction of this landscape infrastructure to the landscape rather, will have a change so as to render the location no longer desirable for users in any sense of the word. It will continue to be so. Their experience of the landscape will be different. The next factor that I'd like to briefly address is the choice of zoning. And that's both in respect of Lake Monbiong itself, and of course the plantation. The choice of zone that's been applied to Lake Monbiong is the PPRZ. It's not, to really respond to some questions put on behalf of Parks Victoria, it's not the PCRZ. And notwithstanding a suggestion that one might expect a location like this to be more typically PCRZ, that's not the decision that's been made for the entirety of the Discovery Bay Coastal Park, inclusive of Lake Monbiong, which has had the PPRZ applied to it. That's also true for the entirety of the Lower Glenelg National Park, all of which is PPRZ. Now, by contrast, the Kobobani National Park is PCRZ, but there is a difference in that choice of zone. There's a distinction between the two. The committee will be very familiar that the PCRZ is at effectively the top of the hierarchy of protected public zones, where the purposes really are directed to conservation and environmental type purposes. By distinction, the PPRZ is the next one down in the hierarchy, and the purposes of that zone include to recognise areas for public recreation and open space, and to provide for commercial uses where appropriate. Now, we're not suggesting any commercial uses are occurring at Lake Monbiong, but it is a relevant point of distinction that the PPRZ has been decided to be applied to Lake Monbiong, which places it lower down the protection hierarchy in terms of those protected attributes. Now, it's an appropriate choice of zone we submit for that location, as for the balance of the Discovery Bay Park and the Lower Glenelg National Park, because of the recreational uses that are made of those locations. So I don't think any suggestion's been made that it's an aberrant choice of zone for those locations, but of course the committee is required to apply the scheme as it's found, and what you find is PPRZ has been applied. In relation to the subject land, as you are aware, it's situated within the farming zone, and that zone necessarily contemplates that land within it will be used in a materially different way than the land to the north and to the south. Now, I've used the words highly modified industrialised landscape because that's what it is. It's a plantation which changes routinely over time and has done for many, many decades. So we've said at paragraph 193 that the differences in the spatial application of those zone controls is manifest in the markedly different presentation of the land relative to its surrounds, and that's obvious to the casual observer. But the last matter I would like to go to before I turn to the final topic is mitigation options. And it's appropriate to observe at this juncture that the evaluation objective that applies to landscape and visual matters is to minimise and manage potential adverse effects on landscape and visual amenity. To minimise and manage. It's not to avoid, it's to minimise and manage. And what we say about that, and I should say that the final topic will be returning to the hypothetical question that was posed by Member Kirsch and what we've done in respect of that question. But I should say first, acknowledge that because of the proximity of the turbine field, or the central part of the turbine field, to the Lake Monbiong campground, that and because of course the height and scale of the infrastructure, it will be difficult to in all cases screen views from the campground, particularly to the turbine field. Now, I say campground particularly because there's really nothing you can do to screen views from the lake jetty itself, and there's practically nothing one could do to screen views along the inland track sections, including the elevated lookout, because you're in a coastal park location with coastal vegetation, and practically no screening mitigation is achievable from those locations. Now, that's not quite the case for the campground itself. Mitigation is possible to an extent we submit in that location. But not only mitigation, but there's an opportunity for improvement of the amenities at that campground, effectively to offset the impacts from visibility of the turbines. Now, in that regard, and at least partly in response to the hypothetical posed by the committee, we asked Mr. Hark to give consideration to the sorts of campground-based and Lake Mombiong-based improvements that one might consider when giving effect to mitigation measure LVO1 and the discussions with both Parks Victoria and the Great South West Walk Committee that are required by that mitigation measure. And we've provided to you in I'll just find the technical note 36, document 381. We've provided what Mr. Hark has provided in response to the request made, and I'll share that document on screen. It's convenient to simply share the aerial image that he's provided. And what you can see there, if I can start with the top right of the image, is an indicative location where one might consider to place a new jetty. And you'll recall that was a recommendation made in Mr. Hark's evidence statement. And his evidence about that location or the benefits of it allows you a view down the length of the lake at an angle away from the turbines off to one's right in that viewscape. But if the committee can recall that when we stood on the jetty that exists, it's a view across the lake directly towards the turbine field location. It's not a location where you can gather an appreciation of the full length of the lake, which is much larger than it appears from that location. But we suggest that there's an obvious benefit to be gained from a second jetty location that allows a view down the length of the lake and also allows access for recreational purposes to a different part of the lake that is otherwise would not be accessible other than through the lake itself. And you can see Mr. Hark's identified a new path or boardwalk that could be constructed to access that location, as well as a more formalised access to the existing jetty. In green, you can see some suggested vegetation locations. In a moment, I'll bring you to the montage imagery from that location, and what we'd say about that is that's where you could have an opportunity to plant screening type vegetation to minimise views where there's existing gaps in vegetation across to the other side of the lake. Of course, all of this is purely indicative, would need to be subject to consideration, and ultimately is a matter for Parks Victoria as the public land manager for the campground. There's a secondary benefit in my submission about the insertion of additional vegetation, which is not just screening benefit, but it allows you to break up and provide separation between camping areas within the campground for privacy for campers and the like. Mr. Hark's also indicated a location where one could consider something like a new day or visitor shelter with some interpretive signage. And the other sorts of matters one could consider include road upgrades, upgrades along the inland track itself, additional or new toilet facilities, and additional or new water tank facilities and fire pits and the like. So there's a range of offset type mitigation measures that one could apply to, in our submission, substantially improve the amenities of a campground that currently has only limited amenities available to campers. And of course, that's a strong advantage or benefit from a project like this that allows you access to funding to facilitate those sorts of upgrades. And that's what LVO1 is directed to achieve. So before I move to the hypothetical, what we simply say about the Lake Mombiong site is that in terms of the merits of the project by reference to impacts on that site, there's a range of contextual factors that we ask the committee to have regard to, as I've just taken you through, that in our submission really reduce the impacts on that location to be appropriate in that context. Now, I'd like to then briefly address the hypothetical and the concept of, as we had understood the question from Member Kirsch to be, what a process, what might be for addressing any determination that impacts at this campground were unacceptable, including by reference to the evaluation objective that I've already taken you to. And fundamentally, as you've heard me say, we would say that it's not an exercise that is needed because the impacts are acceptable in their context. But we did undertake a thought exercise of what one might do, and it seemed to us that there would be, if you like, a superficial response, which would be to delete turbines. And so we sought to investigate what that would mean. And in short, the view that we came to was that even if you were to take turbines away, it doesn't achieve an ultimate objective. And I'll explain what I mean by that, members. And I'll do so by reference to the montage imagery. So what I've done is extract the 4 montages that relate to Lake Monbiong out of Appendix L. And you can see at the bottom of the page is the montage from the campground itself. And what became obvious to us is that when you look at each of the viewpoints in succession, even if one was to take a few or more turbines out of a view out of this view to reduce impacts on the campground, you can see the extent of visibility is already to some extent screened and minimised by the existing vegetation. So you have opportunistic views through gaps in vegetation to some of the turbine locations. And so, as I said superficially, you might think, well, we could take some of those away and reduce the impacts on that location. Our first response to that is that you could effectively achieve the same outcome by applying the sorts of measures that Mr. Hark has indicated, including some well-selected screening locations to reduce visibility of elements to the turbines. So that should be the primary response if it's considered necessary to do so. Our second response was then to look at other view locations, and this is the location from the jetty itself. And of course, you can't screen those views, but what's apparent when you are in that location is that you've got a much broader field of view. And so whereas the visibility from the campground has the benefit of screening and could be improved with additional screening, if you reduced turbines, if you deleted turbines to improve or reduce impacts at the campground, you're not achieving anything from the jetty location because of the extended visibility of turbines. So even if you pull out, for example, the first row, it really doesn't achieve anything from that location. And then we looked at the next level out, which was the lookout location. And in a moment, I'll take you to the Google Earth image so you can orient yourself to where these are from.
Mr. Wright, I'm just going to confirm these are all the images that we already have before us and not additional. Yes.
No additional. This is purely from the LCVAA Appendix L.
Thank you. That's fine.
And so this is the lookout location, which is further to the south from the lake itself. And yeah, it's an elevated location, as you can see the lake in the mid-ground. But again, you've got an extended field of view. So if you've taken out, say, the first row of turbines, it really makes no difference at all to the viewscape from that location. So you don't achieve an outcome through a process that involves removal of turbines, is our fundamental proposition. And really the outcome you're seeking to achieve is to minimise impacts on the point of longest duration view, which is the campground. And our submission in that regard is you're better placed, and the more proportionate response is to apply the sorts of measures that Mr. Hark has indicated. There's the fourth view, which is from it's from halfway along the inland track further to the east of the lake, and that's a location where you have a different set of turbines that are primarily visible. So anything you do to reduce impacts by removal of turbines to the campground has no effect at all at this location. What I'm going to show you now is the Google Earth imagery. Oh, no, that's the wrong one. Apologies. And you can see I've got the layer on, which is the infrastructure. And if I zoom into Lake Monbiong, you can see this. These are the 4 pins for the montage locations. So the first pin here is the campground. That's where we stood. The pin here is the jetty. This third pin is the elevated lookout position. So all of those 3 are the ones where we would say the benefit gained from any removal of turbines is lost for the at least 2 of those. And then the 4th location is over here, where you've got a different set of turbines, which are really visible in the viewscape. The next exercise I'd like to do, well, firstly, I'll turn on the Brolga buffer. Member Kirsch, one matter you were hypothesising about was extending the buffer. The next exercise I'd like to do is to turn on 2 5-kilometre radiuses. And they're centred on, the blue one is centred on the campground montage location, and the yellow one is centred on the location along the inland track. Now, I'm not suggesting there's any magic in 5 kilometres. The reason I've chosen 5 kilometres is that in the response that Mr. Hark gave to your question, Member Kirsch, he used the number of an arc of 5 kilometres. And so there's no magic in that. You could do less, you could do more, but I've just sought to illustrate the sorts of impacts that would be consequent on the project if one was to use an arc of 5 kilometres and delete turbines in that arc. The blue line would result, and this is on the assumption that what you do is you remove the turbines in the blue arc. Now, of course, that's a completely unnuanced response, but I'll just give you the numbers. It's about 38 turbines, or 36% of the project. If you then include the overlap with the yellow line, additionally, it's another 20 turbines, and then you're at the point of more than 50% of the project. We would say, if one was to go to that extent, would be dramatically disproportionate to the impact that one is seeking to address. If one was to extend the buffer, the Brolga buffer, you might be superficially attracted to just pushing it out a bit and then take out this line of turbines. 2 responses to that. It's about 10 turbines, or 10% of the project, 60 megawatts. We would say that is dramatically disproportionate to the impact in context of what the project is seeking to do and the overall benefits of the project. Second response is back to my earlier point. Even if you do that, you reduce an impact for one very specific viewpoint location at the campground, and you have nil impact or negligible impact on the broader view locations. So you don't, we would submit, really achieve anything by removing any turbines from the viewscape. And so we have sought to really fully as we can investigate the process option, Member Kirsch. Hopefully it's apparent that we've given considerable thought to what it would mean and the impacts generally. But we really do think that the proportionate response, the balanced response, is to apply the sorts of mitigation offset measures that Mr. Hark has investigated in that additional document. The final point I'd like to make in that regard is to take you back, as I said I would do, to the Dalburn panel report. And if I can find it. And it's at PDF page 75 of that document, which is again document 352. you'll find the conclusions that were reached by the panel in respect of the landscape and visual impacts of the Dalburn wind farm. And what stuck out to me when I was reviewing this again yesterday is that of course, the planning scheme context and the general context of that site are different to this site. But the conclusions that were drawn really seemed to me to be almost on all fours on the conclusions that we would be asking this committee to draw. The first thing I would observe is the first sentence that you can read under the conclusion adopts a formulation of words which is effectively identical to the evaluation objective for landscape and visual for this project. The panel says, the panel concludes the objective of minimising and managing potential adverse effects for the community on landscape and visual amenity can be achieved. That is exactly the evaluation objective that's to be applied for this purpose to the project. The panel goes on to say, nevertheless, the project will have significant visual impacts on some properties that cannot be ameliorated. Specifically, the panel concludes, the project will be a visually dominant element in the landscape, visible for many kilometres for residents, tourists, visitors and tourists. For some, it will be a negative element. For most residents, the views to wind turbines can be screened by vegetation, but for some landowners, the impact will be high and cannot be mitigated. The relevant planning schemes, the farming zone and rural residential zones, do not recognise landscape values and sensitivity to change in areas around the project. Assessed against this policy context, the landscape and visual impacts are acceptable. The draft permit conditions, etc., are generally appropriate. Now, there's some important points of distinction. Of course, one area there is an SLO, and that does give an elevated level of significance to that specific area. I've addressed yours why we say that's not a problem here. For Dalburn, the impacts were considered, the high impacts were about residences. For us, we'd say the impacts, there's only 6 residences of concern. They can be ameliorated with landscaping if those owners choose to take that up. And otherwise, there's a greater range of public viewpoint locations that fall to be considered here as against Dalburn. But again, in respect of the one that we say warrants further consideration, Lake Mombiong, one could say that the turbines might be a visually dominant element in that landscape, visible to the residents, to the visitors and tourists visiting that location, for whom some it will be negative. And for some of those impacts, they won't be able to be mitigated by landscaping. We accept all of that. But we say the same conclusion should follow as followed for Dalburn, which is that the evaluation objective, notwithstanding, is satisfied by the project in totality, inclusive of impacts on all of the public locations and specifically Lake Mombiong, by the application of the proposed mitigation measures. So I hope committee members and Member Kirsch that addresses the relevant matters in respect of visual matters. Of course, I'm happy to answer any questions.
Look, thank you. That's been very helpful and has largely addressed some of the matters that we raised. Just a couple of very quick observations that might be useful for the proponent to reflect on. And the first is that in your submissions, you're introducing a concept of offsets for mitigating landscape impacts, which is not something that is reflected in LVO1, for example. Perhaps it's just a semantic thing, but that just talks about mitigation, which might lead one to conclude that that's planning and screening or whatever. But you've then talked about the potential for offsets, which might be other facilities that aren't directly related to addressing the visual impact.
I have a ready response for you, Member Kirsch, but I'll need to do it by reference to the EMF itself. If you just bear with me, I'll bring it up.
Yep.
It is a semantic point in our choice of language, I should say.
Look, while you're doing that, the purpose for raising it is if we were of a mind to go down that path, it would be more convincing, I suppose, if there was some certainty around what was being offered rather than a general observation about, well, we'll do some mitigation works with Parks Vic. Now, clearly we need to hear from Parks Vic and they may well have views about that, but I just wanted to raise that or foreshadow that with you now in response to what you've told us.
Thank you, Member Kersham. My response is this. I'll bring up the EMF and landscape mitigation measure LVO1. It's a matter that I had given some thought to, and I was concerned that the mitigation measure related to mitigation only and really screening. But what I had observed, if I highlight this part, is that it talks to mitigation works shall consider additional planting strategies to increase levels of screening at specific sensitive viewpoint, and or to install upgrade existing infrastructure at these locations to improve these sites as a way to offset potential impacts. So it had seemed to me at least that the mitigation measure was directed to the potential for screening mitigation as well as offsetting impacts by the introduction of new or upgraded infrastructure, which is what we had asked Mr. Hark to address.
I'd focused on the yellow highlighted words rather than what I assume was a carryover from the day one. So subject to there being some process with Parks Vic to resolve those works and get a commitment from the proponent, then that may be the way to do it.
Yes, I mean, we're obviously committed to it. That we'll have to wait and see what Parks Victoria says next week about these matters. But of course, there's only so far. What we had contemplated, I should say, further thought had been given to how we could, if we could strengthen this to impose an obligation, or what obligation beyond consultation. But the problem is it's not within the proponent's control because they are not the public land manager for the campground. So the control is only with Parks Victoria, and if Parks Victoria says no, there's nothing we can do about it.
Thank you.
Just to build on that response, I should indicate that we would welcome the opportunity to continue to engage with Parks Victoria during the course of this process in respect of these particular types of measures. And of course, Parks Victoria now has the material prepared by Mr. Hark, and we'd welcome the opportunity to discuss that with them. Okay, we'll look to tie this up relatively quickly. Member Kendall, there are a couple of matters that I want to emphasise in respect of the balance of the submissions. I'm going to go backwards first and ask the committee to please turn to PDF page 43 and to paragraph 162. There's just one correction that we'd like to make to subparagraph B. This is the ultimate recommendations that we seek be made in respect of biodiversity. And you'll see that in some paragraph B, we seek that the committee find or make a finding that there, as we framed it, may or will be a significant impact in relation to the Australasian bittern, that any impact can be adequately compensated. The relevant language should read, if the committee finds that there is likely to be or will be a significant impact, then in those circumstances the committee should make the further finding that that can be adequately compensated. So the change is to change the language from may to is or likely to be. Now, in the balance of the time available, we'd just like to touch upon some other aspects of the written submission. If the committee could please turn to PDF page 52, you'll see that we've set out some observations in respect of bushfire. In broad terms, we rely upon the evidence of Mr. Potter and Mr. Taylor. We look forward to continuing to engage with the CFA through this process. To the extent that any new matters are raised in those submissions, we'll respond in due course. Beyond that, in our submission, the evidence given was both thorough and comprehensive and demonstrates the capacity for the project to respond appropriately to bushfire risk in this context. The next topic that we address is the topic of noise, and there are a couple of points that we wish to emphasise for present purposes. You'll see that in paragraph 208, we've set out certain high-level conclusions. And the first conclusion that is apparent from the evidence is that this is a project with the very clear capacity to comply with the relevant quantitative standards, that is the standards established under the Environment Protection Regulations and Act, in respect of all residential dwellings. And to mirror or echo a submission made in the context of the landscape and visual impact of this proposal, it is no small thing for a project of this type to be able to demonstrate such comfortable compliance with the applicable limits as they apply to residential dwellings. Furthermore, what we note at subparagraph B is that the Environment Protection Regulations also establish quantifiable limits for campsites, and the evidence demonstrates categorically that this is a project that has the capacity to comply with those standards in respect of all campsites, including Lake Monbion. We have made the observation that those assessments are robust. They've been audited by Mr. Spinks, and there's been no contrary evidence that would lead to any proper basis to challenge the validity of the assessment that's been undertaken. At subparagraph D, we make observations about the consequences of those findings in the context of the applicable legislative framework. And you recall that in opening this topic, we took you to the relevant provisions of the Environment Protection Regulations. But what follows from the findings that are clear in the terms of the report are that this is a project that is capable of complying with all applicable noise limits, that as a consequence of complying with all applicable noise limits, it is a project that will not generate unreasonable noise within the meaning of the Environment Protection Act or regulations. And furthermore, that as a consequence of complying with all applicable noise limits and complying with all ongoing monitoring and reporting obligations, this is a project that will be deemed to comply with the general environmental duties specified in Section 25 of the Environment Protection Act. And those three things are very substantial or very significant in the context of an assessment of the acceptability of noise. That is, where a project complies with the applicable noise limits and where it complies with its ongoing monitoring and reporting obligations, it is taken to be a project that complies with the general environmental duty. And those attributes of the legislative framework provide a very strong and coherent basis upon which the committee can ground a finding of acceptability in terms of impact, not just in respect of residential receptors, but also in respect of receptors within the public realm and the campsites in particular. We make the observation at subparagraph E that the committee's findings in this regard are not dependent on a finding that the Lake Monbion campsite is or is not a high amenity area within the meaning of the New Zealand standard. That is, Mr. Dallaire explained that even if that campsite was classified as a high amenity area, the impacts of the project would comply with the more stringent requirements that would apply. And we haven't seen any submissions that would suggest that this campsite should be characterised as a high amenity area, but we're happy to respond to any should they be made. Furthermore, in respect of the impact of the project on the balance of the public land, that is, the public land that are not campsites, we have presented to you an assessment based on the Environment Reference Standard, that is a qualitative as opposed to quantitative assessment, and Mr. Dallaire's analysis demonstrates that the extent of impact would be limited to the extent that noise effects would be audible at all. We don't propose to address you in respect of the traffic evidence in our submission. There is very clear capacity for the road network to accommodate the traffic movements that will be generated. Similarly, we don't need to address you further in respect of the topics of Aboriginal cultural heritage or shadow flicker. I do note in respect of that latter topic, Madam Chair, that you had raised a query concerning the reference to neighbouring dwellings within the context of Technical Note 33 that we'd prepared in respect of shadow flicker. To be clear, the relevant guidelines specify the 30-hour metric as being a measure of the impact of a proposal on the amenity of dwellings. Our use of the phrase neighbouring in the context of the tech note wasn't meant to indicate that that requirement only applies in respect of, or that guideline would only apply in respect of dwellings that weren't participating as part of the project. And indeed, the assessment that's been undertaken has had regard to all dwellings. And what you recall from Technical Note 33 is that even adopting a series of highly conservative assumptions, the 30-hour metric is comfortably met in respect of the vast majority of dwellings. That there were 2 dwellings that were where the 30-hour metric was slightly exceeded based on these conservative assumptions, but they were dwellings in respect of which agreements had been entered into. And in our submission, the analysis demonstrates that the amenity impacts of the proposal on all dwellings, including dwellings that are owned by participating landowners, should be considered acceptable. I won't address you any further on the balance of the topics addressed in this part of the submission, aviation, EMI, or the other topics. But I would like to address very briefly the section of the submission at PDF page 57 concerning design alternatives. The one design alternative that we have addressed for the purposes of this hearing is the alignment of that small portion of the internal power line that runs in the vicinity of Headage Hill. We've described that in the materials as a central option. In our submission, you have before you adequate material to assess the relative merits of the different options. At 231, we note that the proponent confirms and maintains its preference in respect of the central option. It notes in this regard that there are marked cost consequences for undergrounding transmission lines, that is, to construct any portion of the transmission line beneath ground would cost approximately 4 times higher than in respect of an overhead transmission line option. That's of course relevant in the context of this project where so much of the transmission infrastructure is situated below ground. Here in our submission, the central option should be considered preferable to the northern option, and in our submission should not be considered to give rise to unacceptable effects of an environmental nature, and should be considered a matter that is acceptable in the context of the decision-making frameworks. The balance of the submission, Madam Chair, is dedicated to the Day 2 documents. We've walked you through the key changes in respect of those documents. If the committee is able to sit for 10 more minutes, I think we can finish this part of the submission. Is that acceptable to the committee?
Yes, that's fine. Thank you. Just before you do, I have a quick question about the exact alignment of the central option,
yes,
the transmission line. And I know that we've been provided information in document 360 about the preferred reference document for us to use.
Yes.
And I'm just wanting to know if you could explain why that is the preferred reference document. And the observation is it's quite a general diagram still, as in, yes, we may not need more detail for the purposes of our assessment, but I'm just interested to understand why that's the preferred diagram and how that differs from, say, the other version that I've got out of a document that's got the orange version versus the blue and the green.
Yes, the long and the short of it is that the reference that was included was a reference to the depiction of that alignment as contained within the EES. We accept that it may be preferable to reference a different plan.
So it's not actually different in the way it's presented in it. It's just that it's an EES document rather than something.
The decision was made to reference a document within the EES documentation. I think there's other documents outside the EES documentation that have depicted that central alignment.
Yes. But
there's a lot of different documents, and if there's another EES document that we can find,
that's fine.
That was the only decision-making criteria.
Perhaps to clarify, my question is, it's not that it's different in the subsequent documents. It was.
No.
Yes. No, that's clear. Thank you. No
Yeah,
problem.
we just sought to contain it to the EES itself.
Of course. No, that makes sense. Thank you.
Okay. Now, in terms of rounding out the submissions, then the sections that we'd like to address in this concluding part of the submission principally concern the BAMP and the principles of adaptive management. We've, of course, introduced earlier today the changes that we propose be made to the BAMP. I'll invite Ms Guild to address you on these topics, and I'll complete the submission by reference.
Thank you. Members of the committee, I'll only go to the bits that we haven't covered earlier in the day, but the key point from these submissions is just to draw out that the evidence from the experts, from Mr Organ, from Mr Van Oster, from Mr Gibson, confirmed a series of propositions that were explored in introducing the BAMP before the ecology evidence. And the first proposition is that adaptive management is an appropriate approach and the best possible and most effective approach to ensuring that these species of concern are not subject to a significant impact. The second is that it is an appropriate response. Adaptive management is an appropriate response to the precautionary principle. And also that it's the appropriate response to what is an inevitable level of uncertainty about natural creatures, that other than the very common ones that are studied extensively. And one of the very recent DECA documents that was released during the course of the hearings has a very clear acknowledgement of this, and it's reproduced at 246, and says the implication of it being difficult to predict risk up front highlights the importance of undertaking rigorous post-construction mortality monitoring over a sufficient period of time to fully understand the magnitude of collision impacts, which is, of course, the first step of, or the second step of an adaptive management process. And so there's very clear recognition of that. None of the experts, the experts were tested repeatedly about whether there was enough information to make a decision now, and they were tested in all different ways, quite directly. It's like about whether there was enough information about this species. What if we found another species? And they were asked about what's the use of information later? All different ways, all different species. And it was really notable that all three experts just kept coming back saying there's enough. And the only species that they expressed any concern about in terms of needing more information was, as we've repeatedly acknowledged, in relation to the Australasian bittern, where we don't have enough information to quantify with precision the impact. But Mr Organ really explained there that it's not as though we're going to discover that it's there all the time. It's a fine-tuning exercise, and we've footnoted some earlier panels that have noted that that's the appropriate response the appropriate role for adaptive management is actually that fine-tuning. Now, in terms of reporting, which is the next section in this part of the submissions, I took you this morning to quite a number of proposed amendments to the BAMP to make the reporting requirements more explicit and more rigorous. The experts all wanted more reporting, and there's no objection from NEOAN to clear requirements for reporting. It's really up to DECA to specify what it wants, and then to specify the same thing for all the wind farms so that we can have useful comparison studies in the future. The next section is proportionality, which I think I've addressed you on quite a bit today already. And then finally, returning to this question of technology, which is, I'm sure there's many dozens of references to the role of technology in these submissions and other documents. And Mr Chessell addressed you on this orally in the course of the hearing, but we did want to confirm in writing what we see the role of technology and those papers on technology that have been filed, how we see them as relevant to the committee's decision making. So part of the proposed response to the residual impacts on these bird species of concern is the BAMP. It's a very important part. The mitigation measure for the BAMP requires consideration of technology for the purposes of monitoring and potentially detection and curtailment during operation. And that's been picked up and included in the draft BAMP. Now, the attachments to Technical Note 16 provide examples of the types of technology that would be investigated and may be useful for managing impacts, for monitoring, for detection, for curtailment. And given the potential role of these technologies in managing residual impacts, the committee may wish to be satisfied that the technologies show promise for this purpose. It's easy to come along and say, oh, technology, it's the future, it's the solution. And we didn't want to do that. We wanted to give the committee something more substantial than that so it could make a proper assessment of the potential for technology. Now, the proponent is not seeking a recommendation. Technology must be used because we say it has to be checked out. We think there's great potential, but it's something that there is some further work still to be done. And we're certainly not seeking a recommendation for a particular form of technology because that's definitely something that needs some more work. And what we've done instead is set it up in the BAMP that those matters are investigated through quite a rigorous process. And there were quite a few questions along the way about, well, where would you put the cameras and what if they were blocked and how many would you need and where would you put them? They're matters of detailed design. We've had the discussions with the technology providers that have led to those papers to get to a point of confidence that they are just matters of design. And so it's like you've got the functional layout plan for an intersection, and we need the detailed design, but here's the functional layout plan to show you that we can put this intersection in, we can use this technology, but we need the detailed work to be done. And so, the fact that those matters haven't been addressed is exactly what you'd expect at this stage. And Mr. Harks confirmed that the visual impacts are not something that we have to have, are not a determinative feature of these things. And that's very consistent with the images of the technology that you'll see in those papers.
Okay, well, all that's left then is to address what in our submission are a series of high-level propositions that have been established by the evidence and submissions you've heard throughout the first part of this case. And we've set those out at paragraph 257. The first proposition that we contend has been established is that the assessment documented within this environmental effects statement and is supplemented by the materials before you is both robust and substantial. The second is that in light of the extent of that analysis, the committee is in a position to assess the environmental effects of the project and to discharge its statutory functions. The third is that, consistent with the analysis and evidence presented during the course of the hearing, the committee should conclude that the environmental effects of this project are acceptable, that is, subject to the implementation of a robust environmental management framework, and that the project responds appropriately to the various statutory processes. And finally, that the mitigation measures that have been proposed in respect of this project are comprehensive and consistent with industry best practice, and that the EMF and other controlling documents establish an appropriate framework to manage the environmental effects of the project moving forward. And I suppose, Madam Chair and members of the committee, in our submission, this is a particularly important project with very substantial merit. It's a project that has been comprehensively assessed and demonstrated to be appropriate, and in our submission it is a project that should be endorsed by this committee in its recommendations to the Minister. So that closes our submission to you and our case to you. Obviously we will reserve the right to reply to the extent that we need to. As I indicated earlier, we will seek to fashion any further submissions to you to be properly in the nature of a reply to new matters, to matters raised in submissions, and we'll be sure to round out our response to the directions of the committee. In doing that, we'll be preparing a table that reconciles the recommendations of the witnesses or the evidence that you've heard and how they've been implemented. And I'm mindful of other directions about updating our response to submissions. That'll most likely be in the form of the closing submission rather than an update to the tabular response that we've provided to date, unless that's something that the committee would benefit from us doing. The only other matter that I thought we might seek to address in our reply submission is a succinct response to the different terms of or different items identified within the terms of reference to which the committee must address its attention.
Thank you. That approach sounds good. Thank you. Just jumped into my mind then. I think it's document 233 is the RFI, the summary response to RFI. And I'm not sure that you just listed that, but if it's possible to get just an update to cross-check off.
Yes, we will.
Thank you.
Do that. Thank you.
I'll just check if the members have any questions of clarification at this stage. No, all good. Thank you. Mr. Tobin, so thank you very much for your submissions today. And I note that we'll be meeting again next week on Tuesday, so the reserve day on Monday is not required. I can see Mr. Tobin is with us, and I did have a couple of notes for you, Mr. Tobin. With that, I'll just run through now. And on the expectation that you're likely to have listened in to most of today's submissions, I will just check with you. There was some discussion this afternoon about landscape and visual impact assessments from Lake Monbiong and Parks Victoria were mentioned in relation to a couple of matters, and I anticipate that you will respond to those.
Yeah, I've been listening in all day. I'll endeavour to get instructions about the matters that have been advanced in relation to that. We've obviously just got the material overnight in relation to Mr. Hark's assessment, so we'll work to that. It may be that we can go some way on Tuesday, but there is a process of getting instructions. There's an issue I'll come back to in relation to Parks Victoria before we close.
Thank you. No, that's fine. I just wanted to make sure that you were aware of the discussion that was had today. The other issue that Mr. Chessel did mention this morning was in relation to the role for Parks Victoria in relation to the Heritage Rivers Act. So it was just a comment that you may be able to provide some clarification about Parks. I think it was Parks Victoria's role in any decisions relating to that Act. Understanding the proponent's submissions and position is documented in the material that we've gone through today as well. So I think other than advising and confirming that we are starting at 9 a.m, is that correct still, Mr. Tobin, on Tuesday morning?
That's the timetable. We'll have plenty of time. I don't know that there's anyone listed after me, is there?
There's not, no. So we have a day dedicated for DECA and Parks Victoria submissions.
Yeah, I'm confident that both submissions could be delivered within a normal day. I think it was a precautionary measure to list the day early. So I'm really in the hands of the committee. We can start at 9 and maybe get an early mark, or we can start at 10 and do a more conventional day.
So, Mr. Tobin, if you're confident that we can finish in a conventional day, I'm very happy to revise the timetable to commence at 10 a.m.
Let's do that then.
Let's do that. Thank you. So obviously we'll be in your hands to see that we get to the finish line.
Mr. Kendall.
And we'll be appreciative of that. Thank you. I'm sure everybody will be. So at this stage, we'll make sure we send some correspondence out and update the information for parties and observers so they know that we're commencing at 10 a.m. We'll see people, are there any other matters we need to cover from your perspective, Mr. Tobin, before we rise today?
Just one on behalf of Parks Victoria. We've just got instructions today in respect to the same matter we raised in our correspondence about DECA and the EMF /PSA. We think it's unlikely we'll have full instructions on the revised EMF by Tuesday on behalf of Parks Victoria, and we seek the same indulgence until the 9th of July.
Thank you. No issue. No, Mr. Chesler is shaking his head saying that's no problem, Mr. Tobin, and the committee's happy to accommodate that as well. Thank you.
Thank you.
Any other issues that we need to discuss today?
Not for that. Thank you.
Thank you. And just checking online, I can't see any hands up. So thank you to everybody who've been observing mostly online today. So as I said earlier, it's been a quiet day in the hearing room. We look forward to parties joining us and presenting their submissions next week. So thank you, everybody. We'll see you on Tuesday at 10.